Well, here it is, right here.
Oh,
Here it is, right here. So
all right.
you can ask him yourself.
Okay.
Money, banking, and trust by moving titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
You can still hear me. You'll have a chance to ask the question.
Okay.
Welcome, everyone, to this Saturday, July 31st, 2010 edition of Money, Banking, and Trust by Moving Titles in Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology, and we'll do the disclaimer next. Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein reference, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Again, thank you, everyone, for joining us on this Saturday, July 31st edition. Welcome to NTT as New Trust Technology, and we've been going over Book 90 of Corpus Juris Secundum, and we left off on page 848 under section 439. 848 is the page, and section 439 were the Cestui Trust rights of election and waiver. Under A, election between personal liability of trust and pursuit of res. As a general rule, where trust property has been diverted and may still be traced, the City Key Trust has an election to either follow the res or hold the trustee personally liable for the breach of trust. And it is usually held that he is bound by an election one way or the other. As a general rule, where the trust property has been diverted and still be traced, the City Key Trust has an election to either follow the res or to hold the trustee personally liable for the breach of trust. And the trustee is without power to deprive the City Key Trust of such option. If the City Key Trust has exercised his election, it is air to deny the relief sought and make a different election for him. But the City Key Trust is bound by an election one way or the other. Although there is some authority to the contrary, it is usually held, unless the city has proceeded against the trustee personally before he knows that there is property into which the trust funds can be traced, that if the City Key Trust has first elected to hold the trustee personally liable, he cannot thereafter follow the res. While on the other hand, if he has first sought to follow the res, he cannot thereafter hold the trustee personally liable or responsible. However, a previous suit, not to hold the trustee personally liable for breach of trust, but simply to establish the existence of a trust and the amount thereof, does not prevent the City Key Trust from following the trust res property. Effective security for trustee's personal liability, next section. A City Key Trust may pursue trust property regardless of any security he may have by way of surety bonds, and the fact that the Cestui trust has demanded and obtained surety from the trustee for the repayment of the diverted trust property does not preclude the City Key Trust from electing to follow and recover the trust property. Next section, B, election between ordinary property and product or substitute. Where trust property has been diverted into other property into which it can be traced, the original property itself may still be traced and identified. The City Key Trust has an election to take either the original property or the product. Where the trust property has been diverted into other property into which it can be traced, the original property itself may be still traced and identified. The City Key Trust has an election to take either the original property or the product. If the City Key Trust has elected to subject the product or proceeds to the trust, he is bound by his election, and he may not thereafter repudiate it and revive his claim against the original trust property. On the other hand, if the City Key Trust disarms the transfer and recovers the trust property, he may not thereafter impress a trust on property which the trustee received in exchange for the transfer of trust property. Next section, repurchase of original property by trustee. Where the trustee has invested trust property or its proceeds in other property into which it may be distinctly traced, the City Key Trust's right to elect to have the trust attached to the investment is one which the trustee cannot defeat by a subsequent repurchase of the trust property, although in the latter case, the City Key Trust may, at his option, avail himself of his own right and take back and hold the trust property on the original trust. Next section, C, election between lien on and ownership interest in new property. Although there is authority to the contrary, as a general rule, where the trustee has made a separate wrongful investment with trust funds, the City Key Trust has an election either to claim the res as the trust property or to assert a lien or charge on the res to secure repayment of the fund diverted. While it has been held that the City Key Trust may not assert even a lien if the proceeds against the trustee personally and expressly waives any claim, he may have to property purchase within trust fund. As a general rule, where the trustee has made a separate wrongful investment with trust funds, the City Key Trust has an election either to claim the res as trust property or to assert a lien or charge on the res to secure repayment of the fund diverted, as long as the product of the trust property is held by the trustee and may be traced. If the City Key Trust has exercised his right, elected to take an interest in property purchased with the trust fund, it is an error to give him a lien instead. The institution of an action to impress a trust on property into which a trust funds have been invested is itself an election to pursue the res as such. Next section, property purchased with mingled funds. Where the trust funds have been mixed with funds of the trustee in a purchase or investment, the City Key Trust may elect to take a lien on the entire property for repayment of his funds, and he may claim an interest or co-owner in the proposition or the proportion that the trust funds bore to the total investment. And if the City Key Trust has elected to take an interest as owner in property purchased with mingled funds, it is error for the court to give him a lien instead. Section 440, effect of insolvency of trustee. In order to follow and recover trust property in the hands of an insolvent trustee, there must be a tracing of property into some fund or particular property, and generally, the preferential recovery is limited to the extent of the trust property so traced. So some authorities exist for the rule that priority of recovery may be had if the trust property is shown to augment the insolvent estate. The insolvency of the one sought to be charged as trustee does not prevent the application of the equitable doctrine of following and recovering trust property. And if the trust property can, in some way, be traced into some fund or property, the City Key Trust will be accorded the prior right thereto. According to the overwhelming weight of authority, the extent of the City Key Trust preferential recovery is limited to the trust property that he can trace into the assets of the insolvent estate, and no right of recovery or priority exists if the trust property cannot be traced into or identified as some specific fund or thing forming part of the estate of the insolvent trustee. According to some authorities, however, if the trust property can be traced into or in some way shown to augment the general assets of the insolvent estate, that is sufficient to entitle the City Key Trust to a preferential charge on the entire estate, although the trust property cannot be traced into any specific fund or property. But if the trust property has been used in the course of business to pay debts or for some other reason does not swell or augment the general estate at the time of the insolvency, the City Key Trust may not recover as a preferred creditor. A few cases, some of which have been overruled, have gone even further and held it sufficient to entitle the City Key Trust to a preferential charge on the entire estate, and that the estate be benefited by the trustee's previous use of the trust property to pay his debts in an ordinary course of business. Next section, 441, following and recovering as against third persons generally. As a general rule, provided the property can be traced or identified, any third person who has obtained trust property or its products by a transfer made in violation of the trust, or who is not a bona fide purchaser for value without notice, takes the property not only subject to the beneficiary's right to claim it and impress it with a trust, but also to the right of the trustee to reclaim the property. As a general rule, provided the property can be traced or identified, any third person who has obtained trust property or its product by a transfer made in violation of the trust, who is not a bona fide purchaser for value without notice, stands in the same position as the original trustee and takes the property not only subject to the beneficiary's right to reclaim it and impress it with a trust, but also to the right of the trustee to reclaim the property. Thus, property obtained through fraudulent practices of a third person may be held under the constructive trust for the individual defrauded, and even though the person receiving the benefit is innocent of collusion, where a transfer of trust property was not made in violation of the trust, a trust will not be impressed on the property so transferred. A person entertaining into business venture in which a trustee is personally interested is not liable to the trust for misappropriations of the trust funds which the trustee put into the venture, or such knowledge of any facts which would put him on an inquiry. Next section, after settlement or accounting of by trustee. If the trustee, after being decreed to do so on a settlement of his accounts, has paid to the beneficiary any amount equivalent to the trust property wrongfully disposed of, the property cannot thereafter be fallen into the hands of the third person by whom it has been transferred. It has been held that where the trustee has made payments to the beneficiary which would reduce the amount due from him to less than the amount of the property transferred to the third person, the latter is entitled to the benefit of the payments made by the trustee. Next section, 442, bona fide purchasers for value. As a general rule, trust property cannot be followed and impressed with a trust as against one who occupies the position of a bona fide purchaser or encumbrancer for value without notice of the trust. As a general rule, trust property cannot be followed and impressed with a trust as against one who occupies the position of bona fide purchaser or encumberer for value without notice of the trust, including a purchaser without notice from the purchaser with notice. And in order to occupy the position of a bona fide purchaser, the buyer must have acted in good faith until the purchase money was paid, and the person who holds a mere contract to purchase is not entitled to protection under the rule with respect to bona fide purchasers. Next section, 443, mode or manner of transfer. If the transferee is otherwise a bona fide purchaser for value, the manner of the transfer generally does not affect the application of the rule that the City Key Trust cannot have relief against him. If the transferee is otherwise a bona fide purchaser for value, the manner of the transfer generally does not affect the application of the rule that the City Key Trust cannot have relief against him. However, one who takes property by descent from the trustee is not a purchaser within the meaning of a statute protecting the title of the purchaser for value against the equity of a resulting trust. Where a father, in consideration of a bank's extending his son's notes until the father's death, agreed not to modify a bequest to the sons in the father's will, and subsequently conveyed the property to divisees and legatees, the bank's trustees cannot impress a trust on property on the ground that the heirs and divisees were not bona fide purchasers. Next section, purchase at judicial sale. While it's been held, unless there is a statute rendering the rule otherwise, a judgment creditor who derives title to property under an execution in his favor is not, although he has no notice of trust at the time of his purchase, a bona fide purchaser for value, so has so as to defeat the beneficiary's right to follow the trust property. The mere fact that the purchase is at a judicial sale does not make the trust enforceable as against one who purchases in good faith and for value without notice of the trust. Next section, contribution to particular capital, where a trustee who is also a partner in a firm misapplies the trust funds by contributing them to the assets of the firm without the knowledge of his co-partners. A trust, therefore, cannot be impressed on the firm assets in favor of the City Key Trust. Next section, 444, notice in general, A. Although a valuable consideration has been paid, ordinarily a transfer made in violation of a trust does not give the transferee the property free from the trust where he or his agent has notice thereof at the time of the transfer. Although a valuable consideration has been paid, a transfer made in violation of the trust does not give the transferee the property free from the trust where he, as his agent, has notice thereof at the time of the transfer, unless the City Key Trust, by his acquiescence in the transfer, has estopped himself to assert the trust. A trust may be impressed even though there is no confidential relationship between the purchaser with notice and the beneficiary, and even though the purchaser acted in good faith and without the intention of perpetrating a wrong. However, it has been held that a grantee with notice of a trust in favor of a grantor acquires, when the deed contains a general warranty, the grantor's equitable title is trust beneficiary. And the fact that a purchaser, after acquiring a deed to property, proceeds to purchase the interest of the City Key Trust other than plaintiff does not amount to an admission that he knew of the trust at the time he acquired it. Next, time of notice. A transferee from a trustee ex malfactio is not an innocent purchaser for value unless before the time he had no knowledge that the equitable title to the land was in another. He had paid the full purchase price and received a deed to the property. Although one whom trust property has been wrongfully pledged has no notice of purchase at the time of the pledge, he is nevertheless chargeable with the trust if he receives notice thereof before the pledged trust property is sold to satisfy the debt, and at a time when he holds sufficient other collateral given by the trustee to satisfy the debt. Next section, form of notice in general. If a person acquiring trust property in violation of a trust and having actual notice of the trust makes no inquiry into the power of the trustee so to dispose of it, he does not receive the property free from the trust as a bona fide purchaser, and it is immaterial that he does not know who the City Key Trust is, either because no beneficiary is named in the deed of trust creating the trust, or identity of the beneficiary is otherwise unknown. Ordinarily, a notice, in order to be effectual, must be precise and complete enough to put the purchaser on guard. Next section, B, constructive notice. One who acquires property disposed of in breach of trust is not a bona fide purchaser of the property if he or his agent or his attorney acting for him in a transaction is chargeable with constructive notice of the trust at the time of the purchase. One who acquires trust property disposed of in a breach of trust is not a bona fide purchaser of the property if he or his agent or attorney acting for him in the transaction is chargeable with constructive notice on the trust at the time of the purchase. A purchaser is chargeable with constructive notice of a trust, and if the trustee's breach, where he had knowledge of facts and circumstances existing at the time of the purchase, such as would or should put a man of ordinary prudence on inquiry and regard him to make an investigation which would disclose the true title and authority of the trustee, but he fails to make such an the doctrine of constructive notice will not be unduly extended to persons dealing with the trustee. Accordingly, if there is no fraudulent or willful failure to ascertain the facts, the purchaser is not chargeable with constructive notice where he has no knowledge of the facts sufficient to put a prudent man on inquiry as to the existence of a trust, and he is chargeable with such notice only as to facts belonging to the subject of inquiry and to the extent that the existence and nature of the trust would be discovered by inquiry which he is put to by the facts he knows to exist at the time of the purchase. In making inquiry is ordinarily not sufficient for a purchaser to rely on statements of the trustee, but he must inquire of someone having no motive to misrepresent the facts. Records. Next section. Records. A purchaser of a trust property is chargeable with constructive notice of a trust if facts which would give rise to such notice are a matter of record, as where a duly recorded instrument giving rise to the trust discloses sufficient facts and circumstances to put the purchaser on inquiry. The record does not operate as constructive notice if it does not contain sufficient facts and circumstances to put the purchaser on inquiry as to the trust character of the property. A purchaser is not put on notice by rectals in recorded deed to which he is not a party and which lies outside his chain of title. Next section, C, possession of city key trust. Ordinarily, the possession of property by the city key trust at the time of the purchase of the legal title from the trustee is sufficient to charge the purchaser with constructive notice of the trust. Although there are few decisions on the contrary, a general rule, the possession of property by the city key trust at the time of the purchase of the legal title from the trustee is sufficient to charge the purchaser with constructive notice of the trust, provided the possession is so open, visible, notorious, and exclusive as to put the purchaser on inquiry. Such possession by the city key trust, however, is not notice to the purchaser of any right, interest, or title which he may be held by others in the property. Next section, D, matters apparent on face of papers. A transferee of a trust property is chargeable with a constructive notice of a trust where instruments or papers so connected with the transaction that he is bound to take notice of them show or indicate on them on the face that the property is of trust character. A transferee of trust property is chargeable with a constructive notice of a trust where instruments or papers so connected with the transaction that he is bound to take notice of them show or indicate on the face of the property is of trust character. Thus, a transferee is put on constructive notice where an instrument or paper forming part of the chain of title or an instrument or paper delivered to the transferee in evidencing or representing the intangible right intended to be transferred, or other instrument by which the trustee purports to make the transfer, shows on its face that the property is trust property or discloses facts and circumstances sufficient to put the transferee on inquiry with respect to the trust. As a general rule, with designation of transferor as trustee, and a paper or instrument connected with the transaction gives notice of a trust of some description and imposes on the transferee a duty to inquire with respect to the trust, and opening of a bank account in a person's name as trustee gives sufficient notice of the character of the deposit as trust funds. But in the absence of a fraud on this part, the purchaser is not, by the word trustee or other fiduciary words, charged with constructive notice that the transfer is in violation of a trust, whereby a reasonable, careful investigation would not have discovered the true state of the case. Next section, 445, consideration. Although a third person to whom the trust property has been wrongfully transferred has no notice of the trust at the time of the transfer, he is not a bona fide purchaser and takes the property impressed with the trust if the transfer is voluntary and he does not give a valuable or legal consideration thereof. Although a third person to whom the trust property has been wrongfully transferred has notice of a trust at the time of the transfer, he is not a bona fide purchaser and takes property impressed with the trust if the transfer is voluntary and he does not give a valuable or legal consideration therefore. Next section, time of payment. A payment of a valuable consideration to entitle the purchaser to claim the property free from the trust as a bona fide purchaser for value must be made in whole or in part before the purchaser has received notice of the trust or notice of a defect in the title. Next section, what constitutes? In order to have a valuable consideration, there need not be an actual payment of money, but it may consist of some act to be done after the transfer. As a general rule, where the trust property has been transferred to pay or secure an antecedent debt, the debt does not constitute such a valuable consideration and entitles the creditor to hold the property free from the trust as if he has no notice thereof. Such a transfer of trust property to pay a pre-existing debt of a trustee may not be set aside by the city key trust. However, where the third person has charged his position for the worst by paying off or assuming to pay certain mortgages on the property, According to many decisions where the trust property consists of money which the trustee wrongfully uses to pay an antecedent debt of his own to a creditor who has no knowledge of the trust or notice of facts sufficient to put him on an inquiry as to the character of the funds, the money becomes free from the trust and cannot be followed by the beneficiary into the hands of the creditor unless the creditor has not charged his position with respect to the person from whom the fund was received, where the trust property held on an undisclosed trust is allotted as alimony to the trustee's wife in a divorce proceeding, or where the trustee, pursuant to the decree rendered against him in a divorce suit brought by his wife, conveys trust property to his children who have no notice of the trust, the transferees take free from the trust as innocent purchasers for value. Marriage is a valuable consideration, so that a prospective wife of the trustee to whom the transfers the trust properties in consideration of marriage is a bona fide purchaser for value if she has no notice of the trust. Section 446, purchaser from bona fide purchaser. Ordinarily, one who takes by transfer from an innocent purchaser for value and without notice stands in the position of his transferor and is entitled to hold the property free from the trust, although the transferee himself is not a bona fide purchaser for value without notice. With the exception that the trust property can never be reacquired free from the trust, even from a bona fide purchaser for value and without notice by the original trustee, one who takes by transfer from an innocent purchaser for value and without notice stands in the position of his transferor and is entitled to hold the property free from the trust, although the transferee himself is not a bona fide purchaser for value without notice. Next section, actions. Section 447, in general. Except as otherwise provided by statute, ordinarily the establishment or enforcement of a trust is by proceeding in equity, although in a proper case an action at law may lie. Read that again. Except as otherwise provided by statute, ordinarily the establishment or enforcement of a trust is by proceeding in equity, although in a proper case an action at law may lie. Period. Continuing on, except where a particular remedy is provided by statute, the proper form of a remedy to establish and enforce a trust as a general rule is ordinarily a suit in equity rather than an action at law or a summary proceeding. However, there may be circumstances under which the City Key Trust may establish and enforce a trust at law, and as discussed in Section 450, in a proper case he may be permitted to elect whether he shall proceed in an action at law or by a suit in equity. Where there is no objection to the summary nature of the proceedings, the court may properly enforce a trust in a summary proceeding. So I'm going to back up here a little bit. I'm going to read that again at the beginning of 447 there in general, skipping to the last part. Although in a case although in a proper case an action at law may lie, and I want to make reference to Section 422, where it says also the same thing, an action at law may lie, and compare that to Section 421, where it's talking about in equity, an action in equity will not lie. So continuing on under actions here. In accordance with the general rule, and except in cases where the City Key Trust has an election to sue either at law or in equity, a suit to have a trust established or declared may ordinarily be brought in equity only. Thus, a suit in equity is ordinarily the proper remedy to compel a trustee who refuses or neglects to carry out the terms of the trust to execute it. Similarly, a suit in equity rather than an ejectment is ordinarily the proper remedy by a City Key Trust to compel a conveyance of the legal title to land from the trustee unless a surrender to him of the legal estate can be personally presumed. But the trustee, as tenant of the legal estate, may recover an ejectment from his own City Key Trust, who, except where equitable defenses are permitted, has no defense to an action at law. A suit in equity will lie to have the beneficiary of the will procured undue influence declared to be a trustee. A suit in equity will not lie to compel the legal conveyance of an estate in the form of an equitable trust where the law already treats it as a legal estate. A trustee who deals with trust property is not ordinarily liable to an action at law for the conversion of trust property. A fortiori, he is not liable to the action brought by one of the several Cestui trusts for the conversion of the trust property, nor is a transferee of a trustee without notice liable to the action at law for money had and received. However, a trustee may be liable to the suit in equity for the recovery of bonds or money which he has in hand and wrongfully refuses to pay over, or the legal title to property is held by a trustee to secure advances made by him thereon from the owner, and on the latter's failure to repay the advances, the trustee sells the land but retains the title until certain payments are made, and the owner's proper remedy is to redeem the land and not to recover a sum placed on him by the trustee's hands to be paid on the land. Nevertheless, the Cestui trust may, in proper case, enforce his rights by an appropriate action at law. In some cases, it has been held that an action for damages will lie against the trustee for refusal to or neglect to carry out the terms of the trust, as on an implied assumption that he would execute the trust. For example, while as a general rule a Cestui trust can sue his trustee in equity only and not at law for his share of the trust estate or for money due him under the trust, as long as the trust is still open and the shares or amounts due are unsettled, by way of the execution of the Cestui trust, may sometimes sue at law after the termination of the trust. Accordingly, a Cestui trust may in a proper case maintain an action at law to recover money held in trust due him, and where the purposes of the trust have been accomplished, the amount due settled, and all that remains to be done is by the trustee is the paying over the amounts found to be due, even though the assessment of the amounts requires the adjustment of the claim for compensation, or where a sum due him under the terms of the trust is settled and liquidated or as matured. A suit to impress on a trust on real estate has been held to be in rem and has been said to be essentially an action of trespass to try title, although an action in trespass to try the title has been held not a proper means of establishing a trust in an interest in an oil lease. Next section, resulting in a constructive trust. One seeking to establish a resulting trust may do so only by a suit in equity, and he cannot maintain an action at law against a trustee for money had and received. So also in the case of a constructive trust, the Cestui trust remedy for a breach of trust is in equity, but an equitable action to establish a constructive trust cannot be sustained where actual fraud, which goes to the very foundation of the action, is relied on, where plaintiff adversely refrains from bringing a suit in which to be inconsistent with its remedy of enforcing a constructive trust, which he seeks, the court cannot ex moto assert for him such a cause of action. Statutory suit to quiet title is not to be employed to establish a trust in lands. Next section, what law governs. Where a cause of action to establish a trust arises in a particular state, the law of that state is controlling. Next section, 448, injunction and receiver. A, injunction. Ordinarily, the courts will not infer by injunction with a trustee who is properly performing his duties, but an injunction will be granted in any case which the application of such remedy is necessary to protect the rights of the beneficiaries of a trust. Rights of a beneficiaries of a trust. You can get an injunction. As a general rule, a court of equity will not interfere by injunction with a trustee who is properly discharging his duties, and if a preliminary injunction has been granted, it will be dissolved unless it is shown that he is not properly discharging the conditions of the trust or is guilty of misconduct. The court will infer by injunction, at the instance of the Cestui trust, to restrain the trustee from committing acts which are prejudicial to the rights of the Cestui trust. Now, these are all causes of actions you can put in your pleadings, folks. A court of equity will likewise restrain a third person or both the trustee and a third person from benefiting by an act procured as a result of a breach of a trust. Thus, a trustee may not only be enjoined from receiving trust property, but may also be enjoined from committing waste, parting with his control over, misappropriating, or destroying the trust estate. In like manner, a trustee, he may be enjoined from interfering with trust property after his authority has ceased, from submitting or arbitration a question in which the Cestui trust alone are interested without their consent, from making a return and paying a tax on the trust property where such tax is alleged to be illegal, or from removing the trust property beyond the jurisdiction of the court. He may also be enjoined from selling, otherwise disposing of trust property as an impertinent estate in an imprudence or improper manner, or where the title to the property is in dispute so that it is probable that the full value cannot be obtained for it. However, before an injunction may issue against a trustee to prevent the sale of a trust property on the ground of insolvency, it may be necessary to show that he became insolvent subsequent to the appointment, or that there is danger of misapplying the proceeds of the sale. An injunction may issue to keep real property in status quo pending a suit to have a deed covering such property declared a trust deed for the cancellation of the debt. Next section, on behalf of purchaser. An injunction may be granted at the instance of a purchaser from the Cestui trust to restrain the trustee from interfering with his possession, but an injunction will not be granted in favor of a purchaser of trust property merely to enable the court to decree payment to him for improvements he has placed on the property. Next section, on behalf of a remainder man, where a trustee has given a sufficient bond for the faithful discharge of his duties, one who has a remainder interest in the trust estate is amply protected, and the fact that the trust fund is mismanaged by the trustee and in danger of suffering a loss is not a sufficient reason for the interference of a court of equity at such remainder man's instance. Next section, receiver B. Where necessary to the preservation of trust property or the execution of a trust, a receiver may be appointed. A receiver may be appointed wherever it appears that the appointment of a receiver is necessary to the prevention of a trust property or the execution of the trust. Hence, as a general rule, the Court of Equity will remove a trustee and place the trust estate in charge of a receiver where, through the trustee's acts or misconduct of the estate, is in danger of misapplication, waste, or serious loss, and the trustee is irresponsible. Good points here to put in a pleading. Continuing on, the appointment of a receiver, however, in such a case as a matter within the discretion of the court, which is usually reluctant to exercise, and in which all such circumstances of the case are to be taken into consideration. Since it is ordinarily peril of the trust alone which will move the court to displace a trustee from the exercise of his legal rights pending litigation against him, if a case be such that the trust estate is no apparent danger of loss through mismanagement or of a greater injury will ensue from the appointment of a receiver than that from leaving the property in the hands of the trustee, or if any other consideration of property or convenience render the appointment of the receiver improper or expedient, none will be appointed. While it has been held on with proper to appoint a receiver where the trustee omits or refuses to act, or where he is wanting of necessary care in diligence in due execution of the trust, or whether he repudiates the trust, he has also been held that where a mere denial of the trust does not without more justify appointment of a receiver. A proper case of appointment of a receiver may be made out where it is to appear that the trustee is removing the trust property out of the jurisdiction of the court, or has engaged in business enterprise which may endanger the trust estate, or has his interests have become antagonistic to the interests of the Cestui trust, as when relying on a transaction not connected with the trust, he sets up a claim against the Cestui trust. It is also proper to appoint a receiver of a trust estate where such appointment is necessary to prevent the transfer of the trust property, or where on the death of the trustee no proper person can be found to take the trust, but mere insolvency of the trustee may not of itself justify the appointment of a receiver. Where there is a dispute among the parties as to the continued existence of a trust, the court may appoint a receiver to hold and protect the property pending the suit. Next section, C, both injunction and receiver. A proper case in an injunction may issue against the trustee, and in the same proceeding he may be removed as a receiver appointed. Where a proper case is made out, as where a trustee mismanages and wastes the trust estate and persists in doing so, the court of equity may both enjoin him and also appoint a receiver of the estate. But in order to warrant the court in granting such remedies for mismanagement of trust, it must appear that the funds have been invested in some tangible property on which the complainant can equitably claim a lien, nor will these remedies be granted where there is nothing indicating a breach of trust by the trustee or danger to the trust funds. Next section, 449, payment into and out of court. On proper application of a person interested in or entitled thereto, a court of equity may order a trustee to pay into a trust of funds in his possession. Court of equity may, on the proper application of a person interested in or entitled thereto, order a trustee to pay the trust funds which he has in his possession into court where it appears that he is mismanaging or misapplying them, or where there is danger of their being waste or lost, or where he is about to remove them beyond the jurisdiction of the court, but not where he is improperly dealing with them, or there is no danger of being wasted. Next section, on interlocutory motion or application, where trust funds are in litigation and the trustee admits in his answer or his examination, or it appears on a master's report accepted to, or otherwise that he has in his hands funds belonging to the trust estate, such funds may be ordered paid into on interlocutory motion or application by parties beneficially interested, whether or not the trustee has abused his trust or without proof of any danger to the funds. Before such an order is made, the trustee should be summoned to appear and show cause why the money should not be paid into the court. Section 450, election of remedies. The beneficiary may, in the proper case, elect to sue at law or in equity, or he may have an election between or remedies at law. Ordinarily, the beneficiary of a trust may enforce his rights by proceeding either against the trust property or against the trustee personally. Where there's been a breach of trust or where trust property has been misappropriated, one beneficially interested may at the election bring an action either at law or in equity, or may have an election between remedies in equity or between remedies at law. Having once elected to pursue one remedy, the city key trust cannot thereafter employ another. Nevertheless, an election by a city key trust having but a life interest will not bar the remedies of those beneficially interested as remainder men. Where a trust is created to pay the contractor in accordance with the building contract, the contractor is filing a claim against the estate of the creator of the trust does not constitute an election not to take under the trust. The available remedy of one who has conveyed realty to the trustee primarily for the purpose of sale is either an action to enforce the trust and obtain a conveyance of legal title, or one to compel the trustee to redress the breach, but he cannot maintain an action to quiet title. Next section, 451, grounds of actions. Generally, a suit in equity to establish or enforce a trust can be maintained when and only when the facts shown that some affirmative relief is called for of such a character that it may be administered by a court of equity. As a general rule, a suit in equity to establish and enforce a trust to protect and preserve the trust funds or property can be maintained when and only when the facts alleged as constituting the grounds of the action show that some affirmative relief is called for in such character that may be administered by a court of equity, as where the trustee, although without fault of his own, has been prevented from executing the trust in a manner contemplated, and where there are obstacles in the ways of its proper and economical administration which the court can remove, or where the doubt raised as to the proper construction of the instrument creating the trust. Such a suit cannot be maintained where the facts do not show the existence of a trust of which the court can take jurisdiction. I'm going to say that again. A suit in equity cannot be maintained where the facts do not show the existence of a trust which the court can take jurisdiction. or where it is not adapted from any form of relief to which the plaintiff is entitled, as where the proper form of the remedy is a bill for the enforcement of the vendor's lien, or where the complaint is not entitled to equitable relief, or excuse me, where the complainant is not entitled to equitable relief, as where he fails to show facts entitling him to relief. I'll read that again. Or where a complainant is not entitled to equitable relief, as where he fails to show facts entitling him to relief, or where the trust sought to be established or enforced has been created for the fraudulent or illegal purpose, but it has also been held that the trust created for the illegal purpose will not prevent enforcement when refused. Such enforcement would be allowed the person to admit himself as trustee to retain the fruits of the attempted trust. A city key trust cannot maintain a bill in equity against a trustee in possession and a third person who claims an legal title adversely to the trustee to settle the conflicting claims. Where a trustee brings an action to quiet title, claiming title to the property clear of encumbrances, he has committed a breach of trust, entitling the beneficiaries to an enforcement of the trust. A contract from or contemporaneous with a trust arises as not an element of a cause of action to enforce the trust, except as it affects equitable property rights to be protected by defining the parties' rights and obligations under the trust. A statute forbidding the administrator to purchase property of the estate does not preclude an injured person from bringing suit to impress a trust on property acquired by a fiduciary or trustee in violation of his trust. Next section, determination of a former action of a right to enforce a trust and of the duties and liabilities thereunder precludes a subsequent action from the trustee breaches of trust prior to such former action. And I think I'm going to stop there. We'll stop there on section 452, conditions precedents, on page 866 for next time. So let's start the Q&A. And press star 6, star 1 to get in the queue line and ask your question.
Q&A session started.
Press 6, star 1 to get in line. Press star 6, star 1 to raise your hand and get in line for the queue. 805 California, you're unmuted.
Hey, Christian. Thanks for taking the call.
Hey, who's this?
This is Jeff.
Hey, Jeff.
Hey, happy Saturday. So, a couple questions. The NOIs and there's basically a public NOI and a private NOI, correct?
Okay.
In a court case. And then the SOI that supports it, this keeps coming up. Are the green cards essentially in the public? The signature cards?
They're different. They're not the same thing on either side. Everybody always assumes everything is all the same. No. When you flip sides, you usually flip things.
Right,
so
I understand.
Green cards, the facts, that's the SOIs to establish a trust on the transfer of the trust res property into the trustee's hands, and that forms the trust. And that's the private side. That is going to probably be different on the public side SOI. Because on the public side, the SOIs are just the notices, and the notices are the UCC 1s and 3s and the county recorder's filings. And those are the mirrors reflecting from the public side back into the private side, pointing away to the facts. But the notices are just enough public notification that the public can see that there's something there, kind of like a smoke in a fog. And we got to go in chambers to see it clearly.
Got it. So essentially then the signature cards are really, they go into the private.
The signature cards to prove the transfer of the trust res property is on the private side.
Yeah,
you may have green cards on the public side also.
Right. Yeah, I mean, that's just really proof there was a transfer, that there was a delivery.
Yes, because that's the way I know by signature that the guy got the trust res by green card signature, and all the other documentations is just, you know, the trust does not form until the trustee has in his hands trust res.
Right.
And the way I prove that is with the green card.
Yeah. Okay. As far as the private NOI and the private SOIs, I would assume you don't really make a pleading. I don't know, I might be wrong about that, but for some reason the pleadings
side?
seem like they're only... Go ahead.
On a private side?
Yeah, no pleading.
No, there's no pleading. It's private letterogatory.
Right, okay, it's all private letters, right.
Private letters, private letters and orders.
Right, notary presentment still though.
Yes.
Yeah, always notary, everything.
Well,
Public and private.
They got it.
What's that?
How would you prove that they got it?
Right, exactly. You use notary for both the public and the private, really. Certificate of service with a notary certificate of service.
Yes, and
For
you
both.
can use it in other ways, but you can use double witnesses, but I like the
Double,
notary.
double witness is as good as a notary. Is that correct?
Sometimes, if I'm on the public side, I want a notary because the notary certificate stands as bypassing the hearsay rule.
Right, exactly. Okay, yeah, that makes sense. So the SOI is, in the public side, is a pleading, though. I mean, that's basically a supporting pleading.
No, the NOI is the pleading on the public side.
So the SOI on the public side, there's really not a pleading. It's just it's exhibits, essentially, facts. It's material facts.
Say that again?
So the SOI is basically, it's like exhibits of the NOI then on the public side.
What are the NOIs?
Well, okay, the NOI would be basically a pleading basically establishing your interest.
All right, the NOI is the pleading on the public side.
Right.
Now, what is the attachment that goes with that?
Well, that's the SOI. That would be whatever supports that NOI, the evidence that supports that NOI. Is that correct?
And what is the SOI that supports that NOI?
Well, that would be the notices.
The notice,
right. Right, the UCCs and the county recorder.
Yeah, those
That's
are just
right.
public notices that something was done.
Right. Okay. So that's really the only attachments to your NOI.
Yeah. Now we always probably want to put in an affidavit with that of what you did.
Of an affidavit of the points of the NOI. Basically, say you have 6 points in your NOI, so you have an affidavit basically declaring those points.
Support your pleading.
Excuse me?
To support your pleading.
Yeah. And do you do the affidavit in the pleading form, or is it just a regular standard affidavit?
Most statewide, you always have to have either a memorandum in support or an affidavit of support.
Yeah. Got it. Okay. That's pretty much the answer
Now,
to my
if
question.
you think about this, when you get hit with a mortgage foreclosure or some kind of legal action, they always have a complaint with some kind of attachments, and those are usually copies.
Right.
You got to do exactly what they do.
Exactly. Okay. That makes sense. And okay, so your claim, your NOI, it can either be a claim or it can be a counterclaim.
Yes, if you're coming at them, it would be a claim. But if they came at you and you would come back at them, that's a counterclaim.
Do you have to list
claim
it?
and a cross claim or equitable proceedings.
Yeah, equitable. Okay. Is that in CJS, equitable proceedings? What section
Yes,
of CJS?
we went into Book 30A under equity. We went over that.
Yeah, okay, I have to go back.
Counterclaim and cross-claim is an equitable proceeding in equity.
Right. And this is just a random question. It doesn't really have anything to do with it, but I came across this thing called Bill of Discovery in equity, which is really just that's a whole different realm, I guess. That's really just
like 333 terms, Bill and Discovery was changed to, Discovery, not modern term.
And that's all public. That's all just public stuff then, really, essentially.
Public statutory, yes.
Yeah. So it's been converted from equitable into public.
Post 1933, yeah.
Very interesting. We don't really mess with the Discovery because that's just going into the public. That's that law stuff.
Well, I could use the outlaw Discovery side. Yes, I could.
You do that just really as to keep the other side busy, essentially, though, because really I don't want to say the facts are on the moon in this situation, but we're really going to the private, where really whatever that the public has brought to you is kind of irrelevant in the private in a way.
Yeah, you could make them discover, bring up this, bring up that, and then meantime buy some time, and then put together your stuff if you didn't have it ready, and call a hearing for the chambers. Yeah.
Now, if you put in the motion for the protective order and you ask for a motion hearing, I mean, really, it's not a guaranteed ticket to get into chambers, but I mean, they would be denying you due process if you say, well, this is private information, I can't share it.
They're going to deny you a protective order unless there are, especially if there are matters that need to be protected.
Yeah.
I think people that get denied their protective orders are just not they're not showing the court enough to say that there's matters here that need to be protected.
Failure to state a claim.
Yeah, basically, yeah. Because if you don't put the attachments on the pleadings and make a prima facie case, you fail to state a claim upon which relief can be granted, your case will be dismissed.
Right. So
that judge told you exactly what you did wrong, and you're sitting there saying, "Oh, that stinking judge, he did this, he did that, he didn't, and they ran right over me." Oh, you hung yourself.
Yeah. Really, we're just not doing proper due process.
Yeah, we don't know how to do government.
Yeah. Well, who would have thought? I think a lot of us grew up being just misunderstood about it, I guess. Now it's...
Well, all we think we have to do is make a complaint. Complainers, that's all we are.
Debtors. No, sorry. Not funny.
You make conclusory pleadings, which are frivolous and can't be granted anything.
Yeah.
Because they're unsubstantiated with any material facts, even prima facie evidence, which is nothing more than just an affidavit making an accusation, pointing to a competent fact witness that can be heard and put on trial and cross-examined. That would be creating a controversy that the court would hear because you got some kind of testimony to back up your claim. You just can't come into court and say, "Hey, you broke my arm." They're going to say, "I don't see any evidence that your arm is broken." And there it is sitting there half.
Yeah.
You don't have any x-rays attached. You don't have any doctor's determinations. You don't have any testimony from anybody. You got no bills you're attached to it. You just came in and said, "Hey, he broke my arm." What's to prove that so-and-so over here broke your arm? I don't see any claim other than you making a conclusion. Case dismissed. Failure to state a claim. Next.
Yeah. Makes sense. Well, they're trying to protect them.
Judge, this criminal justice system today, it sucks. They're all, no, it was you.
Well, they're trying to protect the public resources.
Yeah, I think most judges really want to help you, but they can't because their hands are tied because they got to go by the rules, and you don't know what the rules are.
Right.
Now, that would be contrary to what a lot of people think, but, hey, I see it more and more and more every day.
Yeah, it makes sense. If we don't know the rules, how can we get any peace?
Yeah, we're our own worst enemies.
So, just to recap really quickly, colorable NOI on the public side with attachments, the evidence, and that's your UCC and your county recorders. Those are considered colorable? Would that be considered colorable SOI?
They're only public notices, and everything in public is colorable.
Okay.
They're standard UCC, non-UCC filing UCC documents.
Yeah.
And then we do not, repeat this, we do not take the UCC filed at the state and put it in the county.
Right.
They will not take them.
Right.
And then you'll say, oh, they didn't take my filing. No, they don't have to.
I
They
found
only notices and affidavits by law. Put it in a notice form or put it in an affidavit form, and they must record it.
Well, I brought a notice to my county recorder in a pleading form, and they read the actual body of it. And I'm like, well, what does that have to do with it? It says notice. Why won't you?
No, I don't want to put it in a pleading form.
Oh, okay.
Pleading
That's
form
good.
is not an affidavit.
Okay, got it. Just regular notice, regular.
All I do
letter.
is I take what I had in the collateral block on the UCC one, paste that into a new document, put a cover sheet on top of that says in big letters, notice, and go file that into the county.
Got it.
And get a certified copy back out.
No problem. Now, I have one other question, because they have this clause in there, they talk about timber and minerals. If you included, like, that in your claim, all proceeds, including any timber and mineral, would that's still acceptable? Because I'm considering ink, minerals, and timber paper. If I put that in the pleading, that wouldn't really, in effect, interfere with the claim, would it? Do you know what I'm saying?
Why would you want to put your private information in a public forum and waive it?
Oh, you're saying timber, putting the timber in there is going to do that?
In your notice?
Yeah. Just putting timber and minerals in there?
Anything you put in the public, you give it to the public and you waive it.
Right. All right.
But if you look at that verbiage that goes into that notice, about the only thing it says is that I've got right title and interest, and it applies to a specific number identifying whatever it is.
Right.
And what you're doing is you're either claiming it or transferring it.
Okay.
And that's all that's on there.
Okay.
Because it's all private.
Yeah.
And if you want any more information on what happened, you contact so-and-so.
Right. Yep. That's in there. Okay. That makes sense.
Now, what you do on the private side, you can put as much detail in there as you want, as long as it doesn't violate, say, your indenture or something.
Right. Oh, and the indenture, you always just give that in chambers. You don't ever mail that directly, right, to a judge. You would, wait till you had an in-chambers meeting to potentially present that indenture.
Yeah, that's all private. That's all private.
Right. So, can you mail? I mean, you essentially can mail stuff in privately, though, can't you? I mean, just by not putting a pleading on it.
Private communication between separate jurisdictions and courts.
Yeah,
and you are foreign to the United States.
Right, foreign, of course.
So it's one court foreign communicating with another court foreign.
Yeah. Got it. Okay. Excellent. Get some notes. Got some work to do. Thanks.
Yeah, it's like a twisty-turny rabbit hole. It's like a road map. You got to follow the road map. You make a wrong turn, you end up in Timbuktu.
Yep. But you can always turn around. And now, what's the rule with the NOIs timing out again? That's 30 days, but based on the day they've received it. And what does that have? How does that work? Is it under rules of court?
Yeah, it's under Supplemental Rules of Admiralty under Rule C. C5, I think, and C6, I believe.
Right. And so that basically just says 30 days and it times out. Yep.
Yeah, the NOI is 10 and the SOI is 20.
Got it. So then you can just put in another one though, couldn't you?
Yeah, if you want to retime it, yeah.
Yeah. And can you do a non-proton on it? Would that matter?
Well, the grantor can be anything he wants. He sets the law form of the case.
Yeah.
But only if they recognize it to be a trust, because you expressed it to be a trust and you got the proof that it is a trust. You know, Gilbert's Law Summary, page 1.
Yeah.
Page 1 says you must determine whether or not there is a trust. Called determination of trust. Page 1.
Yeah.
Got to determine what relationship we're talking about here. Is it trust, or which is a special relation, or is it something else, which would be general? And all other relations other than trust are general. They're general deposits, which give automatic rise to the debtor-creditor, just like we went over right out of corpus juris secundum. Automatic. General deposits automatically give rise to the debtor-creditor relationship, no matter whether it's agency, whether it's bailor, or executor, or whatever it is. They're all debtor-creditor. They're all under commerce. They're all lex mercator. They're all UCC.
Yeah.
All the statute codes are used for the increase the speed of commerce.
Interesting. Okay. Stay special.
Yes, because you can change the nature of a defendant, trustee, under a colorable contract, under debtor-creditor, and change its general nature to special and pull that defendant right out of that jurisdiction and put him into private.
Got it.
Withdrawal and redeposit.
And all that's still colorable enough when you put those on the notices, obviously, in the public, just stating withdrawal of general deposit, and that's still considered, because you are putting that on the notices, telling them to withdraw general deposit.
Yes.
That's not exposing your private information. You're just telling them to withdraw the general deposit.
It was general in its beginning under a misconstruement, under a mistake.
Mm-hmm.
So I'm going to withdraw it. It's public in nature anyway.
Yeah.
And I want to make it private.
Right. So that's, I guess, be my next thing. So on the final, telling them to redeposit, do you just tell them to redeposit in the private? Do you bother to mention special in there? Or do you just tell them to be withdrawing it in the general, and then the next one you're just saying to be redeposited into the private?
I don't have to really tell them it was redeposited. I just tell them it's been transferred.
Transferred. Got it. Okay. Thank you. Okay, I think that answers a lot of my questions for now.
Okay.
Appreciate it.
Good. I'm glad.
Yeah, you're a great inspiration, though. Keep up the great work. I hope people catch up to you and make your job a little bit easier. Thank you.
Okay, thanks. All right.
Bye-bye.
Next caller, California. You're unmuted.
Hello.
Yes, we can hear you. Who's this?
Oh, good. G from California. A couple of questions, 2 or 3. On the A for V and returning for value, do I need to have my IMF revised? And
we don't do an except for value anymore on trust.
Oh.
The except for value is the creditor.
Okay, you don't do that on anything?
No, we don't. We no longer do except for value under trust. The except for value is debtor.
Is what?
Gotten away from that. I don't do the debtor creditor stuff anymore.
Oh, okay. I've heard you talk
We
about...
do something like to that. We do a merger of titles and extinguishment of the debt. Now that's under trust.
Tell me a little bit about that.
Okay. Do you know where my the ForShare site is, where you can get the downloads of the audios?
I don't.
Do you have a Skype name?
No.
No? All right. Do a Google search on the Internet for my name, Christian Walters, and put that in quotes. And then before that, put NTT. NTT in quotes, Christian Walters. And about the first one or second couple ones will come up. There'll be a ForShare site.
Okay.
Click on that ForShare site, and it'll take you to the audio downloads. And you can click on the one that says NTT Debut, which is 11/7/2009. That will get you the beginning point of New Trust Technology, NTT, where we do merging of titles as payment of our bills.
Okay. Good. I'll get that to that. Another question. How, I heard you mention going in and leaning up my bank account. How's the best way to do that?
Yeah, that's some old stuff we were doing. That's pre 11/7 stuff.
Yeah. Is that sort of outdated then?
Yeah, I've totally gotten away from debtor creditor realm, except for value and all the stuff we were doing under that. I can see trust is far superior now after studying it for so long, and that's the only way I'm going to go.
Well, that sounds good. Question: I heard you talk about changing around my IMF. Is that still doable, or is that outdated too?
Well, in that 11/7, let's see, the next one that explains the whole process we're going to be doing would be 1/26/2010.
Okay, that'll tell me how I revise my IMF.
Yeah, that'll tell you how to, our kind of like a blueprint plan of how we're going to do from A to Z, terminate the straw man account.
So I'm hearing you say a lot of in and out. Now, the very first step is to change the IMF, or nothing else would be effective. Is that right, or am I in error?
Well, we're finding that we can do it on a case-by-case and individual basis, and it doesn't affect that. And we can have a individual basis. But to have an overall effect, yeah, we want to terminate the main account and pull out the root and go from there.
Yeah, that sounds like the revision is going to be quite a challenge, huh?
Not really. It's relatively easy, really.
Oh, okay. Well, I'll go have, maybe my sister could get on that and I'll download some stuff. And I guess I should ask,
The NTT trust material is, instead of doing a 75-page lien with all the documentation, all this stuff, we do like a 3 to 5 page thing.
Yeah. Huh. That sounds better.
Yeah, it's a lot simpler, a lot more cleaner, and I think it's going to be a whole lot more effective.
Yeah. That sounds good. Are you still at Moving Titles at Hushmail?
No, that account was closed. Moving Titles at Hotmail.
At Hotmail. Okay. I heard several. Is there any way I can make a donation?
Maybe in the future we'll ask for some money.
Okay. Well, I'll be listening for it and kick down, as it were. Thank you, Mr. C.
Take advantage of all the free audios we got now, because when the website goes back up, we will be charging on that, and then you can make your donations for the audios. The
Have any
audios
idea when you might
charging
be?
for those, though.
Uh-huh.
But these are up there right now. Get them while they're free.
Yeah. Oh, so you're going to be putting the website on shortly, huh?
Yes, because I didn't charge last time, and there was so much downloads that they bait and switched me, basically. But anyway.
Oh, wow. Yeah. Okay,
So
I'm
now to
going to...
get that much bandwidth through there, all you people are going to have to support that because it's going to have to pay for the bandwidth.
Sure. Yeah, no doubt. Okay, I'll see what I can do with it.
Okay. But,
Thank you, Mr. C. Yeah.
Now, are you aware that we have 4 shows a week?
4? No, I wasn't aware of that.
Shows a week.
Really?
Monday,
What time?
Tuesday, Wednesday, and Saturday.
Oh, okay. Would they all be at this number?
Monday, Tuesday, and Saturday are at this number, same time, 10 p.m. Eastern Time, same access PIN number.
Oh, okay.
The Wednesday show is at 8 p.m. Eastern Time, and it is a talk shoe number. And that talk shoe number is 724-444-7444. And the PIN number to access to get in is 41875 pound 1 pound.
Pound 1 pound.
Yes.
And that was 8 o'clock, what, Pacific?
8 o'clock Eastern Time, yes, on Wednesday.
Oh, okay. Okay. I'll be sure and tune in.
Yes, and also there is a private Skype group on Skype.
Oh?
So if you want to get Skype, and we can get you into the group there.
Okay, I'm vaguely familiar with the download. So what, go on NTT or what?
No, you have to go get your computer, download Skype, get the download for Skype, and then it'll get you into it's a whole social chat thing that it's kind of like a browser.
Uh-huh.
And then you want to contact Faith to Trust.
Faith to Trust.
Faith to Trust. Faith, F-A-I-T-H, and the number 2. And Trust, T-R-U-S-T.
Oh, okay.
And tell her you'd like to join the chat. And then once you accept her, she'll send you some agreements to sign or send us, and then you can get in the chat.
Oh, okay.
And I have only one official site out there on the web that is welcome to NTT Christian Walters Group. That's the only chat that I've got out there.
Ah. Okay.
And that's only on Skype.
Okay. I'll see if I can download that and come on in.
So I go to that ForShare site and start listening to those audio tapes from 11/7/2009 and forward.
And forward to January 26th of 10.
Yeah, I keep coming all the way till now, till present.
Oh, you have something in June, do you?
Yeah, there's enough there to keep you busy for a little while. Yes, everything from 11 November of last year till now, 4 shows per week, and at least about 2 hours per show plus. So you got about 10 hours per week.
Oh, that should be enough to keep me busy. Yeah.
Yes, it will be for a little while.
Yeah. Well, I'll go ahead and listen to them, and I'll have some questions arising.
Okay.
Keep up the good work there, Mr. C.
Okay, thank you.
You bet. Catch up with you later.
Got an empty board here, so press *6, *1 to get in the queue line. *6, *1 to ask questions, get in the queue line. Raise your hand. Anybody have any questions? *6, *1. Anybody have any questions? Get on *6, *1. Anonymous, you're unmuted.
Hey, CW, it's Rick, SoCal. How you doing?
Hi, Rick. Hey.
Good. Since you're not getting any calls, I thought I'd bring up my situation here, my continued saga here. The judge, well, I think I told you this. They put a request in for me to comply with Federal Civil Rule 11B, which essentially sounds to me, after reading it, it sounded to me as though he's basically wanting to try my case before it even gets heard. He says, I think I may have mentioned this to you, and if I have, I don't want to rehash it, but I'm pretty sure, I thought you told me to do something, but I wasn't sure if I had told you about this order, because I wasn't on Wednesday night. But within 14 days of this order, plaintiff individually or through counsel will file a declaration under penalty of perjury stating that there has been compliance with Rule 11B of the Federal Rules of Civil Procedure, and specifically stating that allegations for claims for relief in the complaint used by either side to support fair federal jurisdiction comply with Rule 11B. And otherwise, he's going to dismiss the case, and if he doesn't hear from me, and so forth. And then they go on the second page, basically, it's the clerk writing this. If the case remains in the court calendar, an expedited scheduling conference will be ordered under Rule 16B and 26F and the civil procedures. The parties are not required to file any documents before the scheduling conference. Then the last item, what it appears to me like, because this is a federal lawsuit based on fraud, but in the fifth paragraph that they write, it says all parties are alerted to the fact that numerous statutes, programs, and policies are being proposed, enacted, and implemented federally and in California. See, for example, the Housing and Economic Recovery Act 2008, Federal Housing Finance Regulatory Reform Act of 2008, et cetera, et cetera. So basically what I'm getting from all this is they're thinking I'm trying to stop the foreclosure, and this really isn't about my foreclosure. That's a separate act. This lawsuit is a RESPA TILA action, which should, if accepted by the federal court, stop the foreclosure act. There are two separate acts going on. The foreclosure on the right hand, and the left hand, we're suing them for RESPA TILA violations, which we've outlined in the lawsuit. Currently, I'm putting together a response to this, and so forth. So, the first call seemed to have some information, and I was kind of distracted, wasn't able to hear everything. But so I'll go back and catch on to it. But just didn't know if you had some thoughts on this, and if I've already brought this up for you, then just say so, and I'll move on.
So what is their accusation they're making under 11?
Well, 11B essentially says, get it here. Let's see here.
So are they saying that your unwillingness to cooperate in a pre-litigation examination of the facts?
Well, it sounds to me, based on what they're saying here, let's see here, what did they say here? It says, plaintiff's complaint appears to relate to what has been called the mortgage crisis in our country. Many similar complaints have been filed in this court. Based on what has occurred in those cases, the court is concerned, and they give me 2 points. Number one, that all parties to the case receive a proper review of their claims in court. And two, no party is forced, and I think this is the key, no party is forced to spend unnecessary time and expense on the case. The court orders the following to achieve these goals and to avoid an early unfair dismissal with prejudice. So basically it sounds to me like they're wanting me to present all my evidence, which I did present evidence. I quoted cases and so forth. And I know you do trust, but this was filed before I got into trust. So
they're they're doing a show cause hearing, and they're probably going to dismiss it because you failed to state a claim upon relief can be granted because you didn't put in enough of what you needed to, which was the material facts to show that you had a case.
Well, we did 27 pages of information and so forth of different things that they violated. We've showed them. We explained how the rest of it was violated. We explained how the tiller was violated.
Where is the facts to back that up?
Okay, so well, that would be in discovery. Is usually I would thought you would put that in at discovery. Are you suggesting that I should go ahead and submit those facts now?
That's probably the problem. So you have no facts in support. Do you have any memorandum in law or affidavit in support of that?
Yeah, we quoted a whole bunch of that stuff. That's the thing. A lot of that was all quoted.
No, not quoting things. Quoting things just does not support. Where are your facts?
Well, okay, let's just talk through this. What I would present as a fact doesn't necessarily mean that they're going to accept it as a fact. I mean, I could say the moon is green, and that's a fact, but if somebody else disputes that
that's
fact...
not a fact. That's not a fact at all. That's what you think is a fact, but that's not what the court's going to say is a fact.
Right. So I could say, I could put anything in front of the court, and the court could say, well, this doesn't...
No. You just can't put anything in front of the court. The court wants to see facts, and I know exactly what the court wants. And they're going to dismiss this case because you failed to state a claim, because you failed to support it with facts.
Okay. So I need to get the spreadsheet together that calculated the violations and submit that within the 14-day period that they're asking for.
Well, it sounds to me like you failed to make a prima facie case was to support it with at least an affidavit with a proper foundation to support your accusations. Very simple. But so simple everybody misses the point. And then with some kind of material fact like did you have an investigation, a forensic audit by some other third-party independent party that could swear to it that they did that and found violations in your mortgage?
Okay, so I need to bring the third-party witnesses in at this point and get that done.
Yeah, and then those copies attached to it in support, and you got a prima facie case, and you could probably get this show cause knocked out and go into the real thing.
Okay. All right, well, I'll get back with the people I'm working with on that also and make sure
that's what I would do if I were you. Yeah.
All right, that's what I need to do. Another question for you. In order to, let's see here. Well, that's it for now. I'll just sit and wait. I assume you've got somebody on the line by now, so.
I'll go ahead. Got you on the line. Put in another one. Here.
No, I need to think it through a little bit more. So but that was at the top of my head. I'll sit back and listen.
Okay. All right.
I'll hold. Thanks.
Dan, you're up.
Hey, Christian. How are you, my friend?
Good.
Sorry I came into the show a little bit late. I was taking care of some other business tonight. But, I want to say hi to Lisa, too. Hi, Lisa. I'm going to go over with you. Since our chat on Skype the other night, I have... you helped tremendously with just that little bit of chat, answering questions and putting puzzle pieces together, and I wanted to verbally thank you. And then I wanted to go over this with you because I'm going to start putting together my trust, but before I put the trust completely together and actually send it off, I want to make sure that all my I's are dotted and T's are crossed. So,
Gilbert's Law Summers?
No, sir. I've got it on order.
Okay.
You
might want to get the other copy that we have on the download, but it's not quite as accurate because of some parts missing. But
right, I noticed that. I was scrolling through that, and that's why I ordered my own.
The key points is pages page 6, page 18, page 28, page 30,
Right.
page 78. And really, 18 and 78 are probably the two most important ones, because 18 is the elements of the trust and page 78 is the method of formation.
Okay. Yeah, once you have those two down and understand them fully, you should be able to, you should have a really good grasp on the whole trust business.
Yeah, and on page 1, the very first page, the very first paragraph, it says, you know, that you got to determine the trust. So that's like the tests, and you got to test yourself whether or not you got a trust. If you got a trust, then if you pass the test, then, you know, chances that you're getting dismissed for any reason because the trust is not formed is going to be between slim and none.
Right, right. Now, a person, or I hate using the word person. Well, I'm not a person. You're not a person. An individual gets a nice, strong trust down, and it winds up going to court. How versed in equity would you suggest an individual be to be able to go in and handle himself both in the public and private venue? Does he have to be very well studied, very well versed, or?
Well, we've seen some people coming in and just stating those 5 things. My name is so-and-so, is grantor beneficiary, and this hearing is contrary to equity. Trust is pleading special matters as there exists no adequate remedy at law, and I invoke the private side of equity for relief, and...
Stand on that.
Yeah.
Okay. And then once you get in, how does an individual talk to the judge once you get into the chambers with him?
Well, going by what that other party said about the case that they got in there, and says, hey, yeah, come on in anytime, set an appointment. We'll come in and sit down and talk anytime you want, just like chatting side by side.
Well, that's awesome. That's the way it should be. Now, over in the D.C. side, you know, doing negative environments and stuff like that, you always invoke Haynes versus Kerner, which is, you know, that way the judge has to steer around the pitfalls of court. Do you think doing something similar to that, well, no, because you're going to stand strong on those 5 points and not bow down from it, because once you walk in there, you're the judge. And then once you get into chambers, it should be a good man-to-man. There should be no reason for him to steer you around the pitfalls of court. So never mind, that's a dumb question. Okay. I know you always suggest going after the root. But in a mortgage, I had the idea the other day that I got a payoff statement for my mortgage. Create a subtrust, turn that payoff statement into the res, send it back, demand them to you know, distribute and extinguish. Would that destroy the root?
Yeah, that would probably extinguish the debt on the root, but you could also take the security agreement, which is the debt, and merge it with the note, and that does the same thing too.
Merge it with the note. Okay, I know how to merge titles, a debt title and the asset title, but I don't know how to merge it with the note. Where would you suggest I look for that?
Promissory note is nothing more than an asset title.
Right.
And the security agreement is the debt title.
Right, makes sense. How would you merge that?
Just like we've been talking about all along.
Okay.
Actually, 133.
Oh, duh! What am I thinking? Yeah, the title's already created. All I got to do is just pull that general deposit for the note out and special deposit towards the note. Correct?
Yeah, because that's the two titles.
Okay. Pull them both out of general and deposit them both into special. Okay. Now there's suggestions floating around that you take an RA number, one that's already used obviously, and then add some numbers to the back of it, like maybe your initials and then a 0001, and then if you want to use it again on something else, you just put a 0002. Do you suggest that, or do you just suggest a fresh RA number every time?
No, you could claim one number and put a group of numbers behind it, claim all that. You could claim 1,000 different numbers with that sequence, say.
Okay.
And then I could use them all like a checkbook and get all kinds of new numbers based on the one original number. That way I don't have to do all these filings to claim a number all the time. But I would suggest that you did that separate, claiming that number separate, that sequence. And then when you pick a number and you go to do something with it, then do a separate one for that, you know.
And claim via UCC asset?
Yeah, claim all the numbers on a UCC in a county, yeah.
Okay.
Mm-hmm.
All right. All right. You're the master at this. I think I've asked you this question before, but I honestly don't remember your answer because I was so tired that night. You're familiar with Tim Turner Section 1 documents, where you go in and you label you basically rebut all the presumptions that they have against you, and you file your lien on your straw man stuff. What kind of problems could that cause with the NTT, and does it have to be redone or undone?
It's not going to cause any problems with NTT. Otherwise, it's going to cause you problems because what you created, now you got to get rid of. That means you created a bunch of debt. Now I got to go back in there and I got to extinguish that debt. Now, if I got to extinguish something I created, then what was the purpose of creating it for if I got to extinguish it? It just created more work for me.
Right. So just filing a lien on the public record, that $100 billion lien in silver on all your stuff created debt.
It created debt to be used to set off other debt, and it compounded debt, and I created more sin, which was a problem I put on everybody else's shoulders, including mine.
Okay. All right. I'll have to look into going through and bringing that back out, I guess. Because I didn't go through the bonds. I didn't want to feed the beast more money.
So we found out that we really weren't touching the private side at all with that, and now we got to convince a lot of people that, hey, that was all done wrong.
Right.
But now we got the remedy for extinguishing the debt and actually merging it with the private side, with the public side, and getting rid of it. So all I had to do was to accept the offer, merge it with an equitable asset, and give it back to them merged. And that would be the extinguishment of the debt.
Fantastic. Okay. So I go through my deed of trust and my promissory note on my mortgage. I'm going to pull those back out. I'm going to claim them, pull them back out, redeposit them. But I'm going to send those to the original people that I created the mortgage with, correct? Not the loan service.
I would recommend going back to the first signature. You know, the signature on the note really wasn't the first signature. The first signature was on the application. So
application, yeah, that's correct. Yeah, the application. Yeah, that's why I don't have any idea how to even begin to get a copy of that to identify it, so that I can do a survey on that to hold that
but you don't
to the
have
public.
to identify it. It's already been identified.
Okay.
You don't have a copy of the application or anything like that?
I don't think so. I think
you don't have to. All I got to do is just claim it. They've already got it. All I'm going to do is change its nature from general. I'm going to change its nature and character from general to special just by the UCC 1s and 3s and the counties. By my actions that I've previously mailed that stuff before. They got it. I'm just going nunc-pro-tunc. It was a past trust formation, and all I'm doing is just changing it from the mistake that was made under a misconstruement as being debtor creditor instead of trust.
The mistake. Okay. All right. Very good. That seems just as simple to destroy the original, then go ahead and create a subtrust.
Yeah, because if you look at it, you know, there was no money there for them to close it escrow, so they had to create it somehow. So they really created off your signature on the application. so they could advance the money, not out of their pocket, out of your pocket, advance the money into escrow closing so it was there because the note hadn't been signed yet.
Right, yeah. They had to have that money sitting there waiting to go.
Yeah, so then you signed a note. So you got three trusts on a mortgage. You got the trust in the county, which is statutory. You got the escrow closing, which is statutory. You got the securitization of the note, which is statutory. You got three statutory trusts.
My goodness.
So the note you didn't know was a trust, but they knew it was a trust, and they put it right into a trust. They securitized it into a trust. Except you didn't claim it to be an asset, your asset, so they've been taking care of that, and they decided to use that. So.
Okay, well, let's switch gears a second. Let's pretend like we're going to go in, sit down at the negotiation table tomorrow to buy the house. You put down your qualified signature on there. Chances of them accepting that are pretty slim, correct?
Right.
Yeah, because they want to create all this extra debt and make money off the top of it. So your best bet
guys
would
at
be
the table there, they know to look for no other qualifiers on your signature, but they don't tell them why.
Yeah. So your best bet would be to go ahead and go through the normal process, and then within the month, claim it, move it, and all that stuff, and then never make the first payment.
Right.
Fantastic. Fantastic. All right, then. Hey, I appreciate your help, my friend. Tell your lovely wife that I said hello in case she didn't hear me, and I want to shout out to Floyd and Eric if they're on the line. Thank them for their help that they've been giving me too. Oh, and Marshall. I don't know if he's invisible or if he's just gone, but thanks, guys. Appreciate it, and I look forward to talking to you again soon, Christian.
Okay. Thanks. All right. California, you're unmuted.
Thanks for my call. Also, Dan, you might want to put the ellipsis. I think you mentioned that several times on the calls too, the dot before your name on that mortgage, if you're going to go and do that. When should you do that?
Through, yeah, if you could get it through, yeah.
Yeah, because I think that idea seems pretty good. Oh, I'm just trying to prevent anything from being added in front of my name. I mean, really, unless they really get hip to that idea, I think that's a good method also. That way you can go back and
apply as a trust, and then you got the right to sign as trust.
Right. Okay. I have a couple more questions. About a counterclaim, for example. You are at you, and now you're going to write a counterclaim, and you set it up in a pleading form, and basically say a lot of these cases it's always the people are the plaintiff. The people of the state of la la la. So when you're listing your counterclaimants, say there's like police officers involved, there's district attorneys involved, city, the city itself's involved, and the people. Would you list all of them, or would you just list the people?
No, when you come into a counterclaim, you're going to take on a regular claim. You only have two parties.
Right.
All right. You're the defendant. Plaintiff's first, defendant is next. Now, on a counterclaim, there's a second addition block on below that.
Right.
You've got right below that. You put now the defendant becomes the third party plaintiff.
Or counterclaimant. Do you list as counterclaimant or third party plaintiff?
Okay, I could probably do that, I suppose. Counterclaimant, yeah. And then below that is the third party defendant, which used to be up on top, was the plaintiff.
Right, so that's the people of the state of New York, for example.
Yes.
So you don't list any of the individual district attorneys or the officers who were involved in the case.
Whatever it is in the heading, you bring it down and reverse it below that.
Okay, and you list them as defendant at that point, or counter defendant.
Yes, they're counter defendant. Yeah. And
then do you You use the case number if you use the same case number on the right side?
Yeah.
Yeah, so same case number, and then like a bill of equity or an equitable counterclaim for no relief at law?
Same case number, yeah.
Okay, and then I was basically the title of it, underneath the case number, above the case number would be basically a equitable counterclaim, bill in equity for no relief at law, something like that.
Yeah, this is a suit in equity.
Yeah, suit in equity. So that's just basically just kind of rebutting suit in equity.
Well, those 5 things that we mentioned, there's 3 that are really key. I could probably nail it down even to just the 3. And the one is that so-and-so is grantor beneficiary. That's number 1.
Right.
And the number 3 one, which is trust is a special matter.
Mm-hmm.
And number 4, there is no adequate remedy at law.
Right.
I think those 3 are essential to get you into equity.
So so we don't, it keeps switching from no adequate relief or remedy. It's just relief, really. We don't even care about remedy anymore.
No, there's an equitable maxim under equity that states that equity does not do halves.
Right. Yeah.
And that means that if it can't give you a relief in equity, it will go on to the at-law side and give you a remedy.
Right. But we don't want to really refer to the remedy. We're not interested in remedy.
No, let it give you the remedy.
Right. So we're just focused on relief and being in equity. So let them worry about it.
Claim the law form that you want to get, then you can't claim there's no adequate remedy in law.
Right. He who claims equity must do equity.
Yeah, you won't get into equity if you claim anything in the at-law side.
Got it. Yeah, why
You can get at-law remedy, but let the court
grant
do
it.
that.
Got it. No commingling.
Right.
Got it. And then also, okay, so in
Can you hear me?
yes, I can hear you. Can you hear me?
Yeah, I got knocked off there.
Okay, thanks for coming back. Okay. So yeah, the suit in equity, basically the counterclaim complaint, we were talking about that, is basically, when you say you make an amended complaint, what exactly are you referring to when you're saying an amended complaint? Are you referring to...
You're putting a counterclaim in there, so you're amending the complaint.
Oh, okay, yeah. Okay, that makes sense, of course. Just turning in your countercomplaint. Countercomplaint is amending their complaint. Got it.
No, amending your
Amending my answer. Got it. Okay. Excellent. I mean, yeah, it is pretty simple. Okay. And when we talk about debt titles, basically all of their offers are debt titles. Is that every single pleading they pretty much turn in? Would that be considered a debt title? Say they've done a bunch of different, like, conference hearing and...
it's all one case. It's all one case.
It's one case for the claim. That's just one
debt title, yeah.
Just one debt title. And that's basically the original instrument, the original complaint.
All the documentation in there.
Excuse me?
All the documentation in there.
Yeah, all documentation in the case.
So the case itself is going to become a trust and a trust account. And
right.
Everything within it is trust res.
Right.
Including the judgment or whatever.
When does it actually become, do you have to wait for the judgment for there to actually become, where it's like turns into actually an equitable, or there's actually funds in it? When does
the trust form?
Oh, when the trustee receives the res.
Okay. When do you want to form it?
Oh, I want to form it as soon as possible. I want them. It's already formed.
No, it's not already formed. Not till I express it to be a trust.
Okay. Well, is it a trust anyways, regardless if we express it or not?
On the private side, yes. Not on the public side.
Right.
Not until I express it on the public side does it become noticeable in a trust. And that's why I got to test it or prove it.
Right.
So they can say, hey, yeah, you got everything there necessary for a trust. It's a trust.
Yeah. Huh. Okay. And also, on one of the earlier calls I heard about how you guys were doing the DOI, Declaration of Independence, you're signing it and sending it off to Hillary Clinton.
That's for claiming the master trust, terminating that trust account.
Yeah. Could you also use that in a court case to have that as evidence? Is that the law form that you're coming in under? Like you claim that law form by having that as a document as evidence?
I would have already put that in the pleading where that was already put in there.
So you can just state it. You don't need really the evidence. In other words, if you just put it in the pleading, that's sufficient.
Yeah, that's already a public document, so that's not much they're going to say about that.
Right. Well, obviously it seems like the concept of the Declaration of Independence as, moving the courts really seems almost like a moot or irrelevant point mostly. Almost as bad, the Constitution.
Well, 1-103 says, that's how you bring in your law form, really, under commerce.
What was that?
Commerce is on the public side, so that's UCC 1-103.
Right.
And 10-104.
Got it. So that's just because of on the public side, but we're really not using the UCC. I mean, they're using the UCC.
Well, you're using the UCC whether you know it or not. If you're operating on the public side in any way using negotiable debt instruments under UCC.
Yeah. The court's using it.
Yes.
And we're
you're using it too because you don't know it. You're putting your signature on these instruments for them.
Right.
You're making them good for them.
Yeah, that makes sense.
3-115 says, hey, the offer they've given you is an incomplete instrument looking for words and numbers later on. They're going to add to it, make it into a complete negotiable debt instrument for them.
Right. Right.
You never knew.
Yeah.
Now, you want a debtor-creditor relationship, or you want to be in the general side, or you want to make it special by withdrawal?
Yeah.
And a redeposit.
Yeah, definitely. Is there also, don't they mention special deposits in the UCC as well, don't they?
Yeah, they do. Yeah.
So, would you say UCC is basically just codification of a lot of the original trust terms and procedure?
UCC is statutes and codes, all for the purpose of speeding up commerce.
Yeah, but it's been a body of law that's been developed over a very long period of time that was codified.
Jewish Shatar.
Yeah.
Back from Babylon when when Israel was in captivity.
Yes. Sheesh. Okay. All right, well, thank you so much. I think I'm going to go back.
Oh, thanks.
All right, I'm going to get off the call. Have a good night. And thanks, Lisa, and everyone else out there, too. God bless you.
All right.
Bye-bye.
Now, California, you're unmuted. California, you're unmuted. And 1 Capistrano, you're unmuted. (949), you're unmuted.
Hello.
Hello.
Hi, Chris.
Christian.
This is Randy Lee. Hi, this is Christian. This is Randy Lee Harris. I'm in Laguna Niguel, and I am a friend with Rick Gilliam, who's been on the phone with you several times. And
okay.
Here he and I are in several similar situations. I am also facing foreclosure. I just got my trustee sale date on Friday. They're giving me about a little less than 3 weeks from the time that I received the notice.
Yeah, can we kind of like keep things on a hypothetical basis, you know?
Yes, I'm sorry. All right, my question is, in looking over the evidence that we need for our case, because we're both going through the Kelton method.
We've had a case pertaining to, say, a foreclosure.
Yes, okay. The evidence that is necessary, you were talking about forensic audits, you were talking about SOIs and NOIs. I have had letters sent out requesting qualified written requests. They've been completely ignored. When I received the notice originally, it gave me the option to dispute, which would suspend the foreclosure. I responded in a timely manner requesting that. That's been completely ignored. So I have several communications that I have submitted through notary presentment, requesting information, asking them to suspend the foreclosure in order to be able to investigate potential discrepancies with the alleged debt, all of that being completely disregarded. Would those things be considered attachments that I could put in with my case when I submit it?
Yes, absolutely.
Now, you were talking about the difference between SOI and NOI, and I have been telling as fast as I can to get caught up with all the things you guys are talking about. And I understand the SOIs in the private, NOIs in the public. When I submit my pleading, I guess, or my documents for the case, do I submit the actual documents that I have generated to them? Or, because you said, I wasn't clear when you said they're a mirror of each other, one is in the private, one is the public. So what documents would I actually put in with the pleading versus what would I present in court? And also, there has been an audit on my loan documents and violations of multiple laws. Those things I assumed would be included when we actually went to court, but it sounds like those things need to be, everything needs to be included with the filing. I'm kind of confused because I have not received anything other than the actual documents that would be the claim. So can you perhaps clarify for me what I need to present when I go to do my filing versus what I would hold back when I actually, if I get a court date?
Let me go back here and give you some reassurance that probably what's going on. I've reviewed some other hypothetical cases that came about, and the plaintiff's attorneys knew absolutely nothing about the correspondence communicating between the bank and the defendant. But yet the bank never gave instructions to the plaintiffs to do anything otherwise, and neither did the plaintiff's attorney check with the bank, and they kept on rolling through with the mortgage foreclosures, and the judge sanctioned with damages the attorneys and awarded them to the plaintiff for that very fact.
So the fact that
they were dismissed with prejudice. So this is what's going on. The right hand doesn't know what the left hand is doing.
So how do I bring this forth if the judge is requiring to produce evidence before they even allow us into the hearing? What is the information I need to produce? My letters included with the filing?
Are you trying to claim a trust, or are you just trying to do straight litigation here? And, you know, because that's what I need to know first. Are you trying to claim and prove a trust under NTT, or are you just coming in with something that you've already done under straight litigation?
I have only in the last month learned about NTT.
Yes.
And I would like to be able to merge the titles and create a trust. I don't know enough information to actually physically create it. So I'm trying to go back and listen to tapes, read transcripts. It's just very overwhelming.
Okay, so what you're talking about that you have now is just strictly litigation stuff, and you're not talking about applying NTT.
Which leads me to a question I want to ask you. If I merge the titles, as you're talking about, to extinguish the debt, would that end the foreclosure, or would they steamroll that as well?
Well, what you're doing is on the private side, and then you have to get the public recognition of that at a court hearing, say, get them to recognize that you, say, extinguished the debt, and that way they would end the foreclosure.
Well, how would I do that?
Well, that's what we've been talking about for the last 9 months.
I understand, but I haven't had the benefit of being on your calls for 9 months. I'm stepping into a seasoned group that have very sophisticated systems that are way over my head. I don't even have just the basics. I also have listen 9 months worth of tapes.
That's it. You know, I only have so many hours in a day, and I can't give it to everybody else, everything. And everybody's got individual problems, and I can't help everybody individually. I'm not Jesus Christ.
No, I understand that. You earlier mentioned one of your audios back in November. Would that give me enough information to be able to merge my titles?
Yes, over the last 9 months, we've gone over everything you could probably need to know that would cover everything that would get accomplished what you want to accomplish.
Okay, now once I accomplish that, how would I get a private hearing to be able to show this to the judge?
You have to set a motion, a notice of a hearing.
All right, so, okay, now, if I do that, would I do that in addition to the filing? Because I have my documents and I was prepared to go down this week and file a federal case. Would I pursue that as well with all of the documentation showing I've been steamrolled? Or
you only have to modify some of your documentation you got in the court to include claim for a trust in there to where you can get enough colorable stuff that you can set up a private hearing to bring in the extinguishment of the debt.
So in other words, I would need to include some of the issues that they have ignored in the process of trying to get contact with them to slow this down so that I could examine the facts. Those letters include that in the filing?
No, that's on the public side that you're going to use as a monkey wrench to slow down the gearworks.
Which would be, okay, you're saying that if I provided those letters, that would be the monkey wrench, or that I shouldn't? I wasn't clear in your answer.
Well, you have to attach some kind of information on there that would be showing good cause why that, say, the thing shouldn't be postponed because there's discrepancies that have been discovered, there's been violations according to TILA, and now we need to do discovery and discover the real facts.
And that would be in my filing? Now, that's in my filing already. It's 27 pages, and it clearly states there's all kinds of irregularities. Here's what they are. Here's the list of charges.
How long has this case hypothetically been rolling along?
I haven't even filed it yet. I've just got the documents.
No, so they're not coming at you?
Well, the federal case has not been filed, but they're coming after me for a foreclosure. I have been working since January through correspondences, administrative remedies, trying to get remedy, and it's just been completely ignored.
Did you go through the courts on these administrative things you were trying to accomplish?
It was all done privately between myself and the bankers.
That's that thing, See, the court has no notice of what you're doing privately between you and the bank, and the bank isn't coming up with the information. You're not coming up with the information, and the court is going to keep on rolling on with what it is, and the attorneys are pushing it along.
Well, I have recorded, and I did this with another individual. I don't know if I was the right thing now or not. I did do a substitution of trustee, revoking the power of attorney, and a reconveying the title due to elements of fraud. All of that, those proposed modifications were all sent to the lender, giving them 30-day response and 30-day notice on every one of them, and they never responded to any of them other than sending me just a copy of my note. So that's a public record, the recording of those documents that were all sent certified mail. Would that be something that I could submit?
Yes, but I don't think it's going to help you anywhere. How does that tie in with, say, the TILA violations? So you got to give them something colorable that they can see according to a statute and code violation that'll make the court wake up and say, hey, no, we can't have this happening now. And they'll pay attention then because, okay, we got statutory violations against the bank.
Well, the TILA violations are clearly stated within the brief. How much more clear should I make it?
Okay, now it looks like you're not making it known enough because you're just coming up and saying, hey, I got TILA violations. And the bank's going to, or the court's saying, we don't see TILA violations.
So would the forensic audit be a good thing to do, to attach that, or an affidavit of a forensic audit?
Like some of the other people on the calls have said that they're independent third parties, that you pay them, they do an audit, and they say, hey, you got violations according to TILA or whatever it is. Now you got a third party who's got arm's length and clean hands, and you have them fill out an affidavit in their forms to support your saying that we have TILA violations. Now you got some actual prima facie proof to attach to your complaint with your counterclaim coming in and saying there's TILA violations. Now the court can see that because it sounds like you don't have any records attached to your complaint that the court can see as evidence. You're just making a complaint. And if it's not supported with an SOI, your NOI, then you got no case and you will be dismissed for failure to state a claim.
So I need to produce evidence that a third party has indicated there's fraud involved.
Yes. Or you, in fact, yourself, you can make up an affidavit yourself saying that I've discovered fraudulent activity in my mortgage. That carries some weight because you can be a witness.
All right. Well, that gives me a lot more to consider, and I do have some of that on my own, and I can't acquire the other because I have paid somebody to do a forensic audit.
Yeah,
do they have to be?
How much does it cost you to have it? What did it cost you to have it done? How much did it cost you?
I paid $1,000.
Okay. So now you get valuable consideration for an independent service, and now when that party gives you the report back, and then maybe gives you an affidavit to support that, now you got evidence.
The third-party witness that's done the forensic audit, do they have to be certified with any kind of credentials? What is their requirements to be considered an expert witness on this case?
Well, I would say that they have to have some kind of registration with the public to be seen in the public. They have to have a license.
Okay. I don't know if this person is or not. I'm working with Randy Kelton, and I don't know if he actually has a license for that.
No, I don't think he does. You need to get to a licensed one that does.
Okay. Anyone you recommend?
I forget who it was that Carlos said on one of the back shows that we did. He did somebody, it was in California. I forget their name exactly. It was last week, I believe.
Okay, so I can go into your show from your last week's show and look it up, or maybe someone can Skype me if they remember it.
Yeah, I think it was for like $4.99, and they did a forensic accounting for you with the certification.
Okay. Well, I'm on the NTT Skype, so maybe I'll Skype it on there and see if somebody remembers it and they can send it to me.
Sure.
It sounds like that's probably going to be my strongest piece of evidence, is having a forensic audit, someone certified or registered that can attest to the fact there are irregularities.
Yes. Now that's something the court can see. Now you got a witness substantiating your case.
Now, can I ask one more question on clarification? You were talking about NOIs versus SOIs, and I just want, can you go over one more time the clarification? The NOI, the SOI is in private. That would be like a UCC filing. It would be a court reporting.
An NOI can be in the private, and NOI can be in the public. So can an SOI.
Would they be the same thing?
No, they're opposite.
Can you give me an example?
All right, on the private side, the NOI would be, say, a claim for trust, and the support, the SOI, would be the green card, which proves that trust res was delivered to the trustee. Now,
green card meaning like certified mail or registered mail green card, a mail card?
Yes, Form 3811. United States Postal green card
well,
delivery.
I have all those. Everything I have sent out has been sent with a green card.
Okay.
I have a lot of that. Now, is the green card on the public or the private? That's the public, isn't it? Because that's what was sent.
All right. The green card to prove a trust was on the private side. That was the SOI to prove that.
If I went ahead and did a crash course and learned how to how to merge trust, and I had that put together, let's say, in a week, can I do it in a week? Is that possible?
I don't think so.
How long does it normally take?
I'm going to say that there's been other people that have studied crash course for, say, 3 to 4 months, and it shows. Now, those people could probably do this, but that's how long it takes. And calculating the hours involved in that was probably about 1,250 hours.
Wow. Well, then that's not an option for me, even though I have an express trust document.
Now, that's the learning. If you had somebody like to give you the shortcuts and show you the way, then that's a little different story because they could say, hey, do this. But then you don't own the technology.
I understand. But at this point, I have a disabled husband. I'm on Social Security, and if I lose my house, I don't have anywhere to go. So I've got to find some way to get this done.
Right.
And I've been working through a number of different channels since January, and each one has led me closer to where I believe my answers are, and I believe that's with CW, with your trusts. But unfortunately, I've only been a month into this, and I've been listening constantly to all of your audios. But it's one thing to hear it. It's another thing to actually sit down and look at it and do it. You can only. I'm not an audio learner. I'm a visual learner, so it's very hard for me to. I understand the theories behind. I understand the elements you need to have in the trust and the individuals that are part of that trust. But to be able to physically see it and create it with, and I understand UCC1 and UCC documents. I've used those. But to actually have it laid out in front of me and to see each of the elements and be able to execute them, I have not seen them in its entirety. So that's the difficulty for me. It's not the lack of understanding. It's the lack of application.
Yes, it is the lack of understanding. Because if you understood, you could do it.
Well, you're probably right. I understand. I understand it in a general sense, but not in a specific sense where I can actually do it myself. So
right.
Where could I go to get someone to help me, and I'll even to pay them to help me?
Well, see if you can find a TA that would help you along.
I mean, at this point, if I lose my home, I literally have nowhere to go. My husband is completely mentally and physically disabled, and we're on Social Security. We don't have enough to pay rent anywhere, and I got 3 kids, so we have to find remedy.
You out there, and I sympathize with you, and I try to do what I can, but
No, and I appreciate it so much. You have no idea. So if there's a TA that's willing to help me, I'll pay them, and I can learn. I'm a very fast learner. I've got a near photographic memory. But I just need to have someone walk me through it so I can get it done and understand it enough that I can
Are you on
own it.
The Skype chats?
I am.
Okay.
So I guess the best thing for me to do is just to post on the Skype chat and see if anyone is willing to work with me for compensation. Okay. Well, I thank you. You have been very helpful. You've given me a lot more information. I understand, though, on the public side with this case, if I file it, what I need to have to make it substantive for them to accept it so I can even get into the courtroom or even have it reviewed. My biggest concern is present it and have it kicked back because I don't have what the elements they want to see, and you've given me a lot of clarity in that. I really appreciate your time.
Yeah, well, I'll have one other thing ready. I would be ready to file bankruptcy if you had to, because bankruptcy will buy you at least 30 to 90 days more.
Yes, I absolutely, I am tending to do that, but I was hoping that I could get a court date, which might give me more time and use the bankruptcy as the last.
Yes. And then the important thing if you file for bankruptcy is to list the secured party creditors as unsecured.
to list the secured party creditors as well, yes. In other words, my debtors, or my creditors, yes.
Well, your secured creditors, the ones that have the security agreements on the house and stuff.
Correct, as unsecured.
To list them on the filing of the bankruptcy form as unsecured.
Yes, I got that. I understand that and why you need to do that, and that you can be certain that that
was a very good idea.
Branded in my mind. That allows them to separate the debt from the note, from the property, correct?
That forces them to prove up the claim on a B-10.
Very good, very good. Now, I found a document that it's a transcript of an individual that has listed all of the various accounting forms that the banks use to monetize the promissory notes. Would all that information be of benefit in a fraud case to be able to require discovery and to produce those forms, those documents?
Yeah, it could, yeah.
Okay. All right. Well, I thank you for your time. I will bow out so someone else can speak, and if I think of more, I'll jump on the next call. Thank you so much, Christian.
There's 2 points I'd like to clear up there. That upon that bankruptcy there, the reason why that the filing is unsecured there, it's so that when they try to lift the stay, they have to prove that they have the ability to lift the stay by being secured. So that's the reason why.
Okay.
They can't lift
Would
the
it
stay.
make it? I'm sorry. Go ahead.
They can't lift the stay unless they prove that they're secured parties.
They can't lift the stay unless they can prove the secured party, and to prove they're a secured party, they have to produce the note, right?
Yeah, and that's the first thing they're going to try to do. The secured parties will try to do is lift the stay within about the first 30 days. So if you list them as unsecured, they got to prove first that they are secured before they can even attempt it.
But will the courts accept a photocopy, even if I say that it's a hearsay?
A photocopy is
the note. Well, they wouldn't even have the promissory note. I'm thinking of the note. You know, they send you photocopies. It's a unilateral contract. They don't show the promissory note itself. So I guess we're hoping they're not going to produce anything. And if they don't produce it, then it's a default, right?
Yeah, but they'll probably try to introduce copies to the and try to foreclose on copies.
Now, isn't a copy hearsay because you can tamper with it and you can't know that that's the original?
Not necessarily. A counterpart or a copy, when you waive it, can be used as the actual.
Say that again. Somebody beeped in. I didn't hear all of it.
A counterpart or a copy, a duplicate.
Right.
You can waive the original, and that counterpart or duplicate can function as the original.
Can I object to that? Because with technology, you can take anything and make it and tamper with it, and make it look like an original.
Yes, that's the thing, but most people don't know how to object. They don't object right off.
I mean, I have a serious problem with that. You can scan anybody's signature and slap it anywhere. It looks like it's an original.
Yes, right, and that's what they're doing. They're foreclosing on copies, duplicates, counterparts.
Exactly. All right. Makes a lot of sense. Okay. You know, I thought of another question, but I forgot it already, so I guess I'll wait and I'll bring it to the next call.
One other question that was unanswered. You asked about the SOIs, and I answered that on the private side, but I didn't say what the public side SOIs were. The NOI on the public side would be the claim and the complaint or the counterclaim that says that I already made a payment. And then the SOIs to support that would be, say, the notices, which would be the UCC 1s and the 3s and the county notices.
I see.
Where on the private side, it was the green card for the delivery of the trust res. So the SOI are different, But it just depends on what you're applying it to as the NOI claim, as to what the actual document is that is the SOI. So it's just a general term to indicate some kind of document, but then the question is, what specifically is that document as pertaining to private or public? They're not all the same. Everybody assumes all this stuff is the same. It's not the same. We work in a specific, special world, not general. And we've all received a general education which puts us automatically in the debtor-creditor, and they're operating in the special, the specific.
Yeah, that makes sense. Yeah. So we really need to understand what the specific things they want and the specific things we need to use as our evidence.
Yes, and on the public side, it's form, process, and procedure, and on the private side, it's about substantive rights of the real man and woman.
Last question. I've heard people talk about putting liens on homes to cloud title. What are your thoughts on that?
You better prove that it's not yourself doing it.
Yeah, I've heard that too. That's why I asked the question. Because wouldn't that be considered an evasion of the foreclosure?
Yeah, that'll look like the court that you're trying to stop it by doing some kind of fraudulent act.
Yep. That's what I was wondering about, definitely. Now, in the same regard, in creating a trust and collapsing the debt, would that not also look at a way to avoid the foreclosure?
If you don't make it publicly known.
But if you do it publicly, then it's allowable.
No, it wouldn't be allowable on the public. Public policy is against it. But public policy is not law, and equity will not violate law. But it doesn't say it won't violate public policy.
So creating a rest trust in the private would not compromise my standing in fighting a foreclosure.
Correct. And then we bring it in chambers, and the judge can see the evidence, and then he has to colorably kind of like cover it up.
How interesting. You know, I the more I'm learning, the more I think this whole thing is just, it's all a game. It's all a very sick, convoluted, smoke and mirrors game they're playing on the public. Everything is so distorted and twisted.
Welcome to Oz, but it's very simple.
It is.
You just have to understand how things are functioning. And until we change it, we're stuck with it.
Yep, that's true. It's really been educational, I'll say that.
I mean, just like Dorothy in The Wizard of Oz, she had the power to go home at any time she wanted to. All she had to do was click her heels together 3 times.
Yeah, she just never knew it.
Never knew it, yeah. But all along, she was functioning in a dream world because she woke up and she was back home.
True, that's true. It's like the Matrix. You want the red pill or the blue one? Yep, but it's learning. It's learning. It's the knowledge that you attain, that you wrestle through, that you work to acquire with understanding that liberates you. And
yeah, you have
that's
to try to get to the age of majority, so where you understand you can make the choice whether you want the red pill or the blue pill.
Well, most people don't want to know. They want to be left in ignorance. And while all this is fascinating, I wish I had more time to just spend my entire day studying it. But we have to grab the moments when we can. And thank goodness for iPods, where you can listen when you're driving and you're making dinner and taking care of sick people. You know, it's trying to cram a lake worth of information into a thimble. There's so much out there, and one just is layered upon the other, and there's just so much information.
Well, what makes it hard is you have to learn it all now, and that's what's hard. You can't hardly do it. I mean, we should have been doing this over the last 12 to 18 years.
Well, I so appreciate the fact that your diligence and your own research has unearthed this, and that now it's coming to light is extremely illuminating. And it just changes the way you see everything. Very different, very different. It is. I can see where in the end we will live with a lot more liberty, but it's understanding who we are and learning how to live in the private. We have been so inculcated in a system that's so destructive for so many generations. And it's, like you say, it's coming out of Oz and learning what the truth is.
Yes, but we created that realm ourselves.
I realize that. And it's been passed on generationally, so those of us that were there in the inception have just accepted this illusion, and now we're making the choice to come out of it. But now we're in a crash course to learn the realities.
Right, right.
It is. Well, thank you very much. You've been very helpful. I really appreciate it.
Okay, all right. Thanks for coming on.
And I will back off and let someone else come on the line. Thanks, Christian.
Anonymous, you are unmuted.
Hi, Christian. It's Rick again, SoCal. Question came to my mind. If someone has done the Tim Turner docs and filed the UCC and then recorded the actual UCC in the county and so forth, would someone need to undo that before they merge titles on their house? If the house is already claimed in the Tim Turner UCC property documents that were filed and recorded?
Well, it's like if I pull the root out, there might be some residual dried plants still around, but it really has no effect. But I would like to go up there and sweep out the debris and clean it all up. So I would say, yeah, I would go back and revoke that, but you don't have to do it right now. Do it later. We don't have time.
So that would not affect someone who's wanting to merge titles. It wouldn't affect someone who's trying to merge titles and do it.
Because the title's going to cut off at its root. And when it dries up, because it's laying there with no life to it, because it's been cut off, it's still laying there, but it's dead. And now I can go back and sweep it up later.
Okay. All right. When you said the private NOI is a claim for trust, that's a written document that you create?
No, that was the green card to prove that.
Oh, I thought you said the SOI was the green card.
Yeah.
Private. I'm talking about the NOI.
The NOI?
Yeah, the NOI on the private, you say claim is the claim for trust. Is that a document that you create with the...
That would be my indenture with my intent and purpose and
that document would have the description of the property and the promissory note information?
Right.
Okay. And then that is what is in the private. And then the green card is the private SOI. Okay. All right. Just wanted to clarify that. I'll sit back and listen to... Oh, wait. Well, I did have one other question. What you were saying about creating a cloud on the title, if someone was to create a cloud, so if someone was to create a California certification of trust per our codes and so forth, with a trustee, naming a new trustee and so forth, and file that, that would be considered a no-no?
Well, let's say that if I did a mechanics lien against the property for some improvements that were done, I'd better make sure that I have a mechanics lien issued out of a corporation that was, say, a separate entity.
Exactly.
And maybe I might be president on that entity, but then I would have the legal right, because of separation of entities, to make a claim against the property. Now, that would probably be illegal. But if I myself personally put a lien against my property for making house improvements, the court would probably look at that and say, hey, no, you can't do that.
Okay. All right. Thank you very much. I'll sit back and listen. Thank you.
Okay, we've got an empty queue line, so anybody, *6, *1. There was somebody in there dropped out, though. Chris, you're unmuted.
Christian?
Hey, Chris.
How are you?
Okay. How about you?
I think I might have some quick remedies for some of these folks. Gonna hold on for a minute. We're running around the office here. It came up in one of our cases out here in California just last week that a bankruptcy attorney, in his dealings with helping people save their homes in bankruptcy, filed a homestead. And today was my day for going through about 150 pages of homestead. And I wanted to find out if you'd like me to read a quote, which is very applicable for everybody on the phone, that they can get immediate equitable relief.
Yeah, go ahead.
Okay. This is under Corpus Juris Secundum, under Proceedings for Enforcement and Protection of Homestead Rights. This is under Section 155. The rights under a claim homestead exemption may be added in an independent action brought for that purpose. The owner of a homestead may maintain an action or assert a defense for the protection or enforcement of his homestead rights, or to prevent its denial or infringements, as where the homestead property is or is about to be unlawfully sold on execution or a consummation of a fraud. A particular court has been held to have jurisdiction to determine whether or not the property is within the homestead exemptions for the purposes of protection against the orders of execution and sale. Courts of equity have inherent jurisdiction to afford relief in respect of the protection of recovery of homestead property where the rights of the owner therein has been infringed or are in jeopardy through no fault of his own. It has been held that it has been held a court of general original jurisdiction necessarily has jurisdiction whenever a homestead exemption is claimed, and in an action pending therein to determine whether the particular debt is or is not one of which a homestead may be seized or sold, and whether the claimant of the homestead exemption possesses the qualifications necessary to entitle him to the homestead. Time to sue. I will skip that part, but I wanted to go over to injunctions because I thought that was real interesting for this gal that was on the phone just a minute ago. This is under 156, nature of actions or proceedings in which relief granted. Here again, this is what is under homestead, of which she can file at any given time. Although there is authority to the contrary, it has been held that the question of homestead exemptions may be raised in an injunction suit. The fraudulent grantee of a homestead cannot maintain trespass against a creditor of a fraudulent grantor who seizes on execution. The general rule that equitable remedies are not available if they are an adequate remedy at law applies to remedies for the enforcement or protection of the homestead rights. Homestead rights may be claimed and allowed in a suit to marshal liens against the property which have been fraudulently conveyed. And then this is the injunction part that I thought was, it says, it may be proper to determine a claim of homestead exemption in an action of quiet title. Injunction, since a judicial sale, even through invalid cast of cloud, on the debtor's title to the homestead so disposed of, an injunction will lie, here's that will lie again, at least until the determination of the right or claim to the homestead exemptions against the unauthorized levy of the execution or a sale of the premises. The court will not, however, determine the homestead rights on affidavit filed on the motions for temporary injunction to restrain a levy, nor will the injunction issue where the applicant has an adequate remedy at law. By protecting his homestead under the statutes of exemptions, as where the sale would not defeat complaints homestead rights. A proceeding to enjoin the sale of the debtor's home on general execution, the creditor may successfully defend by showing that the claim on which the execution rests is expected by statute from the homestead exemption. The granting or denial of a temporary injunction is a matter of discretion. The rights of the injunction to restrain a sale of the property under judicial proceedings is predicated on the absence of any adjudication in such proceedings of the claims to a homestead. And I can go on, but there was another part that's really something that a person can use here, and this is the rights to possession during the period of redemption. And this would give that gal enough chance to learn about the trust stuff and whatnot. It says, the homestead property is sold under execution. A claim of homestead filed prior to a judgment ordinarily carries with it a right of judgment debtor to occupy the premises during the period of redemption. This rule, however, is inapplicable where the judgment represents the purchase price of the homestead premises. The homestead property is sold at the mortgage foreclosure sale. The judgment debtor has a right under such statute to occupy during the redemption period the premises used by him as a homestead if the premises are actually occupied by him. Under these statutes, proper proceedings would be taken by the judgment debtor in order to establish his rights to possession. Where the homesteader retains possession of farmland, we won't read that part because that's just about farmland, but going back to the injunction, it goes for 2 or 3 more pages into summary remedies and whatnot. I would suggest everybody is to go into your corpus juris secundum and look up, this is under volume 40, look up your homestead rights. Homesteads are a one-sheet paper that you have notarized and have it filed at the county recorder's office, and you put a claim to the property under equity. So I would say that would be the first, quickest, fastest way of getting some protection on your properties, especially since you live there.
Yeah, we claimed a homestead before, but we lost, and I think the reason why we lost now that I studied equity more was because we really didn't claim equity. That's important.
I think so too, with my findings and whatnot. And I think what that gentleman that came on the call with the 5 elements on Monday, I think that that's very pertinent. Anytime that you do a unlawful detainer answer, that 5 elements should go in that answer.
Right. Yep.
Part of your response. But I think that that was pretty much it. I was very thrilled since we're looking at this whole idea about putting injunctions together to help people. I thought that this was a very pertinent spot for everybody to research.
You enjoying those CJSs?
Pardon?
Are you enjoying those CJSs?
Yeah, you know, I'm like a kid in a candy shop, CWA. I can't wait to get to my next book. My next book for tomorrow is going to be land patents. Because what I'm reading in this 150 pages under Homestead is that it's a precursor to doing a land patent. And so, yeah, I'm really enjoying it. I did secure those other CJSs over at his law bookstore and still trying to make a deal with him. He sold me this set for $2 a piece for each book. So I would say that he's more than likely to strike the same deal on the rest of those books. It's a broken set. I offered that to Eric, but he didn't seem to want to respond, so I didn't want to hold up the program. If somebody wants those, they're welcome to get in touch with me. I'll see if I can't secure them for them.
Okay.
So that's it for right now. Get to the next person if you wish. I just wanted to read that part because I think, you know, for filing the bankruptcy attorney, when he filed a homestead, to preserve the property. I thought that was an excellent thing that an attorney did. Oh, by the way, there is an equitable lien that you can put against your property, and you can file that on a UCC. It's called an appreciable equity lien. And you can actually, what I did is I filed it as a appreciable sweat equity lien against the property, and I did that on a UCC1. And that is your investment because you've got proof that you've paid mortgage, property tax, and upkeep of the property, and those are the things that you're claiming. Doesn't Florida have a permanent, because I was reading it at a CJS today, that some states make all properties under homestead, and I thought I heard Darren Michaels tell me that all of Florida has a mandate homestead on all the properties down there.
Yeah, but if you do your research, you find out that the homestead is there's an exception. And the exception is for taxes. But if you notice what the court does, it taxes everything. So everything the court taxes then is exempted, then the homestead doesn't mean anything.
So do you have to actually go in and file a different type of homestead in order to take care of business, per se?
Well, I think when we filed the homestead there, let's put it this way, when we tried to enforce the homestead, we didn't claim equity. Now, that may have made a difference right there. But in reference to what's that equitable lien, going in with the equitable max and equity abhors a forfeiture, says today a mortgagor refers to his interest in the property as his equity. The origin of this concept, however, was actually a mirror image of the current practice. So equity today means what I have an interest over above the value, what I paid for the property. But original equity, that's not what it means. It means the mirror image of that. It means it is my interest.
Which can be anything under trust law, right?
Yeah.
Like so trust res.
Yeah, here it is, the change from trust res to something of commercial value for the purpose of commerce.
Which is just like a debt instrument, like an FRN, which is negotiable. It can go up or down depending on the commercial market.
Yeah. Yep.
But if it's considered a value without being in commerce, that could be any type of value or any amount of value.
Yeah, just the opposite, unlimited value.
Yeah.
But no value really pertains to it because
it goes back to a man's house as his castle. It could be the wreck of the neighborhood, but if he's happy, and that's, I'm just using that as an example, but that's his castle. It's more valuable than anything else. Just like what this gal was talking about earlier, she doesn't know what she would do and where she would go, and everything I read out of this homestead today said that it is in direct preservation. In fact, there was another part in here I was just absolutely floored. Let's see if I can locate it. Here it is. In accordance with the object of homestead provisions to permit one's place his family beyond the reaches of financial misfortune, if the intention of the debtor when he occupies land as the homestead is to make it his present home, the exemption may nevertheless be secured, although he also intends thereby to prevent his creditors from subjecting the property to the collections of their debts, as by converting assets from a non-exempt to an exempt status prior to the bankruptcy filing. However, homestead intentions cannot be used as a shield for fraud. And I thought that was a good quote.
I think there's a difference between a, say, pre-1933 homestead and a post-1933 homestead.
Did you say that you had the Corpus Juris Secundum that was before 1933? Do you have the full set?
I don't know how far mine go back. 1955, I know the oldest one so far.
It'd be interesting to go back and find out what was really what the original. As close as I got, it was squatters' rights, and when properties were being handed out by the properties were being handed out across the nation, where they would do homesteading. That would be putting a flag up and claiming a parcel that was being offered for free. That was back in the 1860s, I believe, of where you could just go in some form of a raffle. That property would be the claimant. And
the post-33 homestead was probably going to be in the statutory realm, which is probably full of holes by now, like Swiss cheese.
Well, I found something very interesting in my just pretty much thumbing through to the important parts of this 150 pages. Christian, they're actually talking about the Bankruptcy Act and how homestead was a provision post-1930s. It must have been redefined, but they're actually got case law that supports some of the comments about the provisions of the Bankruptcy Act of 1933, and I thought, well, when I get a little more time, I'll go back and check that out, but I just wanted to bring that to your attention. They're actually talking about the Bankruptcy Act and the provisions that it set forth for homesteading. So for anybody that's interested in listening to this, that was intriguing to me. If I had the time, I would have gone back and looked up some of these cases, but those are some of the highlights that I was looking at today on the homestead. I would certainly strongly recommend people fill out a one-piece sheet of paper, have it notarized, take it down to your county recorder's office for $15. It's going to get you right into equity.
Yeah, that's my question. Is this going to be a statutory equity because we're recording it into a post-1933 statutory realm?
Yes. It actually speaks very, very much so, but it also says that no judge, oh God, I wish I could find that section. It says no judiciary and no judge, there is no one that can touch a homestead with a 10-foot pole unless there's some kind of defectiveness or deficiencies, like the person's not living on the property. From what they're talking about, even though it's under statutory, it's under constitutional statutory law. That's how it was put forth. It's not under any other sets of laws other than constitutional statutes. And a judge can't even penetrate it. They can't fool around with that. When you scream and say that you've got a homestead, they pretty much have to back off and honor that, because that's something that it said it more than twice, probably more than a dozen times, of just skipping through 150 pages, that you tell a judge that you got a homestead on a piece of property, and he has to act accordingly to that.
Well, I know in Florida that doesn't work because that didn't help. Well, it didn't help us at all.
Yeah. Well, you know, I was kind of I wanted to talk to Darren about that because we were talking about it the other day, and he sent me Florida's one of the websites down there and I wonder how that weighs in with states that you have to actually manually go in there and file your homestead.
Well, I think the key is invoking equity and make sure that it sticks in equity.
Well, here's an interesting part. The constitutional or statutory provisions prescribing what shall be contained in a declaration of homestead are mandatory, and a compliance therewith is essential to the acquisition of the homestead exemption, and a declaration which follows the Constitution or statutes will be sufficient. Excuse me, I'm sorry.
We did that. We did that. We did that. Didn't work.
Well, maybe you should have taken it.
Got a nice, pretty little decoration, but it didn't work.
Well, maybe you should have pushed the envelope and did a land patent to back it up. I got a kick out of this, and I think that this is especially for California people. I know that California is a little bit different than back there, but this is a quick fix to get your foot through the door that shows that you're not a renter. And on these unlawful detainers, if you're not a renter and you've got a homestead, they can't do an unlawful detainer. I know that much. And that's a done deal. That's material fact. As soon as they know that you've got a homestead on a property out here in California, unlawful detainer doesn't apply. So even at that extent, if that's the only protection you get out of a homestead, you know, it's worth it. $15 or $25, whatever it costs to get it filed.
Well, proper equity enforcement for that.
Yeah, and I think that that's something that could be discussed because I'm putting papers together right now, quiet title papers, and I got at least 5 hits out of looking at this homestead that filing a quiet title action supports, and in almost every case from what they're talking about in the corpus juris secundum, once you do a quiet title action to support the homestead, it's a done deal. It's recognized and acknowledged and adjudicated, and therefore you're granted exemption from creditors. So I would say that that would be the ticket for a lot of folks out here, too. I don't know much about the quiet title stuff. Do you know anything about that, Christian?
Somewhat, yes.
Yeah. Do you have any supporting information you can send me on quiet title?
I got a few things, probably dig it out.
I would really appreciate it because that's up on my menu for things to do this week. I would really appreciate it if you could send me something. And, you know, if that gal, you know, since she's here in California, I can probably pass her some of this California stuff. I think she said she was down there where Carlos is at, down in San Diego area. So you could have Lisa have her contact me if she wants, and I could probably give her a few pointers on what she can do.
Okay.
So that's it for me tonight. I'll let you get back to talking with some other people. Thanks for the time, and you can send me something. That'd be really great.
All right, Chris. Thank you. Carlos, you're unmuted.
Good evening, Christian. How are you doing?
Hi, Carlos.
Fine, thank you. I just want to clear up a little bit on Rick. He called me before Chris. He asked about the certification of trust. He did not know how to ask that question. I think that he wants, and he can correct me if he likes. I think that he wants to know if it's a good idea to convey your property into a land trust. The reason I'm saying that is because you would not need a certification of trust if you have a land trust. So, in your opinion, is it a good idea to convey a property in a land trust, Christian?
Yeah, I think it saves the property for a time being, as you can get it, say, put into a more private trust.
Right. Because what we want to do, we have to get it out of our name for probate. You know, the probate BAs that they go through if someone dies, the asset protection, and now it makes a little bit of protection because now it doesn't belong to you, and the bank wants to get something that you gave him. You gave him like a promise to pay, and the house is not on your name anymore. It makes it throws a little sand in their gears. That's what I'm trying to say. But his question was that was his question. And also, on quiet title, here on quiet title, after a foreclosure, the judge will tell you, look, you're in here. The reason they go to fight a unlawful detainer in court, and the judge says get out, because that's not the right venue. They have to get it into a higher court. There's no way. Even the judge will tell you have to go to a different venue. There's no jurisdiction here, and you can do a quiet title. Now, if you're going to do a quiet title, you have to have some grounds. You're not just going to say there's fraud. Yeah, but support it. You have to support it, right?
That's when you come in with the forensic examination
and also the foreclosure examination. Now you have something to fight back. You have some standing, and good luck. That's basically that's all you need to fight back. You don't have that. I don't care what you do. They're going to shine you off. I've seen it more than once. That's all, Christian. I just want to make that point a little bit clearer. All right.
Okay.
Thank you.
Thanks, Carlos. Okay, I guess that's nobody else. So, Anonymous, you're unmuted.
Yeah, this is Rick again, SoCal. Appreciate Carlos' clarification on that. I was not sure how to ask the question, but I thought I'd try. So thanks, Carlos, and we'll be in touch. But based on what Carlos just said about the trust, and based on what Chris just said about the homestead, I need to find out if either one of those would violate or cancel each other out, or can they work in concert with one another. Because if you're taking the land and putting it in a trust, then are you still able to claim a homestead?
Good question on that one. Might not be able to, because the
trustee is different.
The owner would have to be the one that would be filing the homestead. So you'd probably have to do the trust first, and then maybe file, if it's a public trust, statutory trust, then file a homestead on for the trust through the trustee. But now, if it's a private trust, it wouldn't make any difference because then we're going to know.
I probably need to call Chris and then get back with Carlos and try to sort that through, because I don't want to step on my toes here. I only got 10 days to go, so on my sale date, and still trying to get the lawsuit lined up correctly. I got 3 days to do on that one.
I think a lot of people tend to throw a lot of spaghetti at the wall hoping something will stick, and all they did was they made a mess.
Right.
Where I would throw one meatball that would stick.
Right.
I think you got salad here, and that's what you got. You got fruit salad. You got a mixed up fruit salad.
Well, the issue, I respect, your endurance and doing your years of study, but kind of like Randall said, the bottom line is when people like us get to the point where we're willing to fight and look at this stuff, it's usually at the last minute and near at the end of the term. Therefore, it becomes extremely difficult to pour in all the knowledge that you have in 10 years of doing this or more, and everybody else has, and then try to make a comprehensive meatball. Because you look at T.T. Ted Turner, you look at Brandon Adams, you look at Greg Jenner, you look at all these people doing stuff, and you look at C.W. and what you're doing, and it's like that's what we have. From our perspective, it is a salad. So what we're trying to do is find the ingredients that is going to work for us, and based on what we've learned in the last 3 weeks or so listening to you, all the others that we've talked about or listened to and studied, for a month or so, that gets wiped out based on trust. So, that's the hard part about making a meatball that's going to stick. So, I agree with you what you say, but from our perspective, looking at it from the outside in, that's the tough part for us, and that's why we end up with a fruit salad. But that's why I'm asking the question, because I'm looking at this trust here, And I'm hearing Chris. I'm like, okay, Chris is making sense, but you're telling me based on experiences that you know about that didn't work, but that may be because no equity was claimed. So my next question then is, let's say we do a homestead, let's say, or someone does a homestead, how would they claim equity on a homestead? Would they have to do a UCC1 to do that? Or, I mean, how, because if it's just a document that you file.
Yes, it would be in the document that you filed in your pleading or your motion, that would have to invoke equity. It would have to have those equitable switches in there that turns equity on, which ours didn't. And then maybe that was the reason why we didn't get it. I don't know.
And the equity switches would be?
This is a suit in equity. There's no adequate remedy in law. You know.
Okay, so the foreclosure.
That is the equitable relief. You know, things like this. You know.
Okay, so then the actual sale date, you'd be quoting the sale date because there's no remedy. You'd be quoting the foreclosure itself, the sale date, as the equity. There's no cure for those in law. Therefore, we're claiming equity, and thereby invoking homestead.
Yeah, something like that. Yeah.
Okay. All right. That's cool.
I know for that what we did not work, and we claimed homestead, and even had it backed up and support with facts. You know. So,
yeah, it just you already know what's going on. It's late. I don't want to wait. You know, we all know it's a lot of garbage out there, and unfortunately.
Well, and I also know for a fact that 3 lines put into a court took a mortgage foreclosure off the sale block only because it was coming in and saying that there was a trust here.
Yeah. Okay. What about would it be power in or? I wouldn't, because I was thinking today of sending a letter to this maybe, I guess it'd be MERS and Recon Trust. They're the ones that are named on the sale date. So sending them a direct letter.
Especially in your mortgage, you know, if MERS is in there,
yeah.
You got an automatic win. There's no reason why that house should be foreclosed on.
Right.
MERS is knocked out.
I'm sorry, it broke up.
MERS has been knocked out. MERS is knocked out. Somebody just didn't bring it in right and prove that fact.
Okay, but that's getting into the lawsuit thing. Would there be any power, or is there any reason why I should not send a direct letter to Recon Trust or MERS regarding my sale date, letting them know that there has been a lawsuit filed against BAC, and that they don't have a right.
All the trust people out there, what they're missing is,
yeah.
It says MERS as nominee.
Right.
Who made them nominee?
Well, the BAC made them nominee, or Countrywide. In the original case, it was Countrywide.
No, you did.
Well, I granted to Countrywide to choose who they chose.
Right, right. Through a power of attorney that was probably applied.
Right.
Revoke the power of attorney and cancel MERS' nomineeship.
Okay, let me write that down. Revoke power of attorney. Okay, revoke power of attorney and cancel.
Cancel the nomineeship to MERS. Fire MERS.
Now, I would send that directly to MERS and to BAC. That's all parties in this recon trial. And do by notary present.
All interested parties, yeah.
Yeah, okay. So that, when I do that, should I also put in the fact that I've asked for a debt qualification and it hasn't been answered? I've also given them a second notice and they haven't responded to that also. Should I also put that in there? Or should I just keep it succinct in just the MERS part?
Well, like what I was reading tonight, anybody who was given notice cannot be a bona fide purchaser. So if you've got any kind of evidence that you could put somebody on notice with. Now they can't take free and clear at any kind of sale.
Okay, because the lawsuit was only given to BAC, is their agent, so I could...
Now, this was a past mortgage foreclosure. It's been done. It's been months ago or half a year ago or more, something like that. Now you've discovered new evidence that you can come in with and have a retrial, or if you can't get one, put in a new case.
Right. Okay. All right. So then that...
Get a stay, get an injunction, get it all stopped up. Now you got more time to come in with the trust stuff.
That's what I'm trying to do. So I actually, when I write it, should I write it in such a manner that I'm demanding, that we demand this to be happen because of this, this, and this, or am I...
I don't write any nice letters. I write notices and demands.
Right, okay. All right, notices and demands. So I'm putting them on notice that I'm revoking the power of attorney and that I'm canceling MERS nomineeship. And then, do I record that notice? Would you suggest doing that?
Yeah, you could do that because it's colorable notice anyway. Statutory.
And record. Okay. All right. And so I'm just looking for, 3 to 4 months here to put things on ice so I can get my feet under myself and get this thing adjudicated correctly. All right. Thank you again. I'll sit back.
I'd like to speak about that very topic. It was kind of like there's so much confusion out there from all the A-to-Z methodologies available to everybody that nobody knows what's up with any of them.
Right.
And what we really need is like a practical guide, or better yet, discernment as to what all this stuff is. But it really comes down simple. It's either general or it's special. I think I talked about this at the beginning of the show, that general, what is it that's under the general and what is it that's under the special for those two simple realms? Because now you got some way of classifying stuff as to what it pertains to, and now you got some way of better grasping and getting a handle on it.
Well, I make myself a T-chart, and on the left is the white, special, private, etc. I mean, I understand what goes on that side. On the right side, I have the black, the general, and the public, and so forth. So I've mapped it out, and I see it. I guess for me personally, the hard part is understanding how all the components interact inside those, on each side of the tree, or a divide that I've made. So that's my difficulty. So it's just getting that picture down.
Yeah, but I think where we mess up is we come from details on up to general, I don't know, that's a bad word to use at the top, specificity on the bottom with the details, as to on the top we come down to like 1 point. And we get confused because we start at the detail end and we get so much confused about the details. And really we should be starting at the opposite end, coming down from the point or into the details rather than coming from the details and working up.
So understand the concept and then plug in the information below the concept.
Yeah, because I'm swamped about the details, and
right.
I can't make a decision because there's so many details here. I don't know which one to pick.
Well, that's how I feel, believe me.
That's
exactly.
Confusing. No, we're starting at the wrong end. We should go to the other end and come down to, okay, everything is either general and special comes down to the next level because there's one level above that. The one above that is what is general and what is special. We're talking about relation. Mm-hmm. At the point, the pinnacle is relation. And the bottom of that relation is all the details on the bottom of the pyramid. Mm-hmm. But we should come down from the point, the relation, down to the next level, general and special. Now come down one more level. What is general? What is special? Well, special is trust. General is everything else that's not trust. Now we start seeing what things are. Let's start plugging in them examples of what are not trust. So we got agency, we got Baylor Bailey, we got executor, administrator. All this stuff is general. But then if you know that general is all commerce and all of general is public, and then on the other side special is private, now it becomes simple to tell what realm do you want to operate in. And then make your choice. Do you want to operate in the private? There's only one thing available to you. Special. That's trust. If you want public, if you want general, that's debtor-creditor. Pick the realm you want to operate in.
Right.
It's up to you. It's your choice. And then you can worry about the details later on.
And equity would be on the left side, and law would be on the right side, where the black would be on the right. With the,
yes.
Right. Yeah, that's. I think I've got it understood that way. Like was mentioned earlier, one of the things for me is if I could see how paperwork is put together, and then ask questions about the paperwork itself with somebody, with me, and we can figure that out, then that really helps me personally to understand, all the concepts that we're reading about and trying to incorporate, because, by putting it in front of you, it's what I'm very good at. I'm not, when I used to slot car race, I could never come up with my own design that was great, but I could take somebody else's design and make it extremely better, and win. So that's, originality is not necessarily something that I have a gift for, but taking something that I see that works, and then after I've understood the process, I can manage that and tweak it and make it even better. But that's just me. And
you know what the problem is there? You know what the problem is there?
What's that?
Is because you were using the building blocks of somebody else because you didn't take the time to learn how to design what you needed.
Well, I used to design some stuff, but it was never the best, but I could see somebody else's design, and then I could take it and make it work even better. I don't know. I can see where you say that, and I don't doubt that's probably true. I'm not going to deny that potentially, but not everybody learns the same way, and I think that's the key. It's if everybody could do originality, then
yeah, but I think all people or all human beings are equipped with all the learning that they need, except when I was 13, a major light bulb went on in my head. When I came to the conclusion, it was the technique on how to learn something, how to learn. And I became, instead of being fed a fish from a fisherman daily, I became the fisherman. And I realized that I could go anywhere and learn what I needed to learn because the information was out there. All I had to do was do the research.
But the problem is, if everybody was fishermen, then who would make clothes, and who would make hats, and who would make cars, and do that? So I agree with you that you have to be a fisherman, but not everybody is astute or gifted enough to be a fisherman in the legal realm, but they may be gifted in relational realms, so they may be gifted in other areas.
Yes, right.
So you're right, we need to learn to fish in the gifts that we've been given, but not everybody's been given the same gift to fish through Gilbert's Law and CJS.
That's
I'm reading it, but my head spins, and I have to stop, and it's not a fast read for me. And and so I understand what you're saying, and I agree.
Easier as it goes along. It gets easier as it goes along.
Yeah, well, that's because we haven't been trained. You're right about that. Once you train your brain to work through things in a certain way, then it will reprogram eventually and make it easier, although it may not be perfect. Like Randall says, she's photographic memory. I can remember things when I'm talking to people much better than I can remember what I've read. But that's just how I operate. But she can look at something and she can type while we're talking and be accurate. I can't do that. So it's just different gifts for different people. And I think that's a good thing in the long run for everybody because it helps make us interdependent, because what you do well is not necessarily what I do well, but maybe some of the things that I do well is not something that you do well, and we can help each other in that area. So anyway, I don't want to be philosophical at this late, but I just want to say thank you for what you're doing, and I do learn and I do appreciate your views and suggestions. So I just want you to hear that.
Okay, thanks very much.
You're welcome.
Okay, it's after 3.5 hours almost, so let's call it a night. So tonight's Saturday, so we'll see you Monday at 10 p.m. on the Trust Ambassador call. So